Good. Oh, excuse me. Good morning, Telegram. Good morning, Sonya. We are in the home stretch of the Karen Reed trial. Today is going to be closing arguments, and hopefully, the jury gets charged. So, we're just here trying to get it cracking. Good morning, everybody. They just had their sidebar, so hopefully, Mr. Lally or I firmly believe that Brendan gonna try to do the whole closing. You know, I think he's gonna try and do the whole closing. But if Mr. Lally does, I see him over there holding something. So Mr. Lally may be going first. We don't know. But I'm so disappointed that we didn't even get to watch we're not able to watch the cash out trial. So I'm still out here searching for a feed or to even see if there's any other news stations down in Atlanta that are going to show it or even just maybe upload it after the day after court. I think we see that a lot with the YNW Melly trial. And just to let you know that there is also a status hearing going on for YNW Melly. And so I'm actually looking for the feed for that. Because y'all know we got to keep up on on the YNW Melly trial. There's usually a station that plays it. I can't remember what that station's name is. I want to say is it NBC? Is it NBC? I'm looking for that station. If there's a station that usually plays it. So good morning, everybody. Happy Friday. Welcome to the chat. Make sure you hit that like button. Make sure that you subscribe if you haven't done so already. All the good things. All right. Let me make sure that we turned on y'all, we hit 3,000 subscribers. Yay! I'm so excited about that. So we've been trying to break 3,000 for the longest, and we have finally reached 3,000. And now we are on to the next goal of 5. We got to get 5,000 people over here subscribe to the Taylor Umbridge channel. So I guess the cash out trial bumped us up yesterday. That's what the people wanted. We had a lot of folks over here yesterday, around 40. The most I seen around here was like 48, 46, which is great. So we just gotta make sure that we NBC 6 South Florida. Thank you. Y'all look at CB. CB didn't got him a new name. He is now the 13th juror. But we have hit 3,000 subscribers. I'm so excited. Like, that just made my day. Yay. So I'm looking for that NBC 6, and I'm going to look and see if they are going to stream Melly's hearing today, because y'all know I absolutely want to know what's getting ready to happen. Absolutely. Honestly, the Melly content gets us a lot of views. So hopefully we get us a good update on what the hell has happened over there, or we get some documentation uploaded and submitted through the court. So we'll see what happens. I'll keep my eye out on that. The Melly stuff is supposed to start I think it was scheduled for 8:45, so they should already be in session as well. So hopefully we get something through. I'm also, like I said, I'm still looking for day 2 of the cash out trial. Okay, yep, I'm seeing everybody show the opening arguments, but I'm not actually seeing anyone with day 2. Did y'all see that woman pass out in the courtroom? Oh, this was 7 years ago. Because I don't know why this is playing, but this woman passed out in the courtroom after she was found guilty. Oh Lord. Sorry, y'all. This is fascinating to me. This woman about to pass out in the courtroom. This was 7 years ago. This is Diana Lovejoy in California. She looked like she was definitely one of them Stepford wives. Oh yeah, yeah. She passed the hell out. It looked like she having a seizure. Good Lord. I was looking for Cash Out as well. They did have court yesterday. Try Fox Atlanta 5 News. I did, and they don't have it. They absolutely had court yesterday, but I guess that they didn't put the cameras out. I guess they put the cameras out. Good afternoon, Starfish. How's it over there in the UK? Love probably got the cameras out the room. Okay. And that's weird to me too. Why would y'all stream the opening arguments and not the rest of the things that are in the court? Like, that's really, really with that. Well, it's very annoying. Let's say that. It's very, very annoying that they would do that to us. Very annoying. And so I'm just trying to. Hopefully, we get to see Melly though. All right, because they usually do not skip a Melly. NBC usually does not skip a Melly update. So maybe they're going to be out there for Melly. Let me go check out Bryce's. Okay, let me see, y'all. I'm gonna go to Bryce. Is it Bryson or? I could have sworn the man name was not Bryson Tiller, but I could have sworn the man name was Bryce. Okay, let's see if I can find him. I don't think I can find him. Short break while the jury enters, y'all. It's about to go down over here in the current retrial. trial. Now, CB, I need you listening. Since you weren't here today, I was just about to ask where you was because I haven't gotten an email from you in a while. So I need to know. I need you to hit me up and let me know what you're watching because I feel like we out of touch. I feel like we out of touch. Did the man unfollow me or something? Did it block me? He may have blocked me or something. Shoot, I can't even find him. Okay, here it is. It is Bryson. Bryson Boone. So he didn't block me. All right, so to commemorate 2 years, I'm gonna host some X Spaces at 2 and play a couple clips from the original YNW Melly jurors. I talked about the first trial. Okay, so maybe not. So Bryson has not posted anything about it. He's one of the people that I one of the accounts that I would go to over on Twitter to see something about it, but it looks like he's gonna be hosting a Spaces a little bit later today. Is the other trial with the girl killed her boyfriend still going on? Oh, are you talking about Megan, the woman who killed her husband and had her boyfriend help her at the corners? Yes, Megan is still going on. If that's who you're talking about. Megan is still going on. Okay, yeah, we can go back. I was gonna come back live yesterday. I'm like, we can watch Megan, but I ain't think nobody else wanted to watch it. So I didn't come back on and play it, but Megan Jackson's trial is still on. We can go back and watch it if you want to. We sure can, beta girl. Oh, I didn't eat that. Mm-mm-mm. All right, so nothing yet over Melly either. So hopefully we get us a little Millie update sometime today. Maybe Lawn Crime will post it after it. Lawn Crime will do that too. They'll record it and then they'll post it afterwards, and it'll be something for us to watch. Let's just hope that everybody is aware that these are the things that are going on today. I don't know why Lawn Crime got themselves down there doing a cash house trial, but like we said, it might just be that they put the cameras out. Yep. So I tried Atlanta Live. I've tried 11 Alive, excuse me. No. I've tried 11 Alive. I've tried Atlanta News First. Because they were covering it too. Let's see, Atlanta News First didn't even wait a minute. Okay, well they did have a clip yesterday. That's all that they posted.
Gibson, who is better known as Cash Out. A jury was seated. Opening statements began today. Gibson is charged with rape, sex trafficking, and luring women into prostitution. Court records say he and 3 others allegedly formed Pires Music Group LLC, but then used the company to recruit women to engage in commercial sexual activity. One of the first witnesses called to the stand was a corporal with the Gwinnett County Sheriff's Office.
Mm. So I gotta reshare. It said that there was no audio, so I'm gonna share again to make sure we get our audio back. If the video starts and we don't have audio, just let me know because it did StreamYard be tripping. And I heard it was tripping yesterday. So it's probably for the betterment of everything that I didn't go back live yesterday. But 158.05. I think I didn't go back live yesterday. 8:05:50. What? Child, what the fuck is going on? Yeah, she would just be. I know. Girl, I just got to be minding my business. Nope, Cat didn't post anything either, Beta. Throw me a. Can you hear me? Are you able to hear me? I just want to make sure that we got audio. Yeah, you. I say you might be able to hear me because I'm just talking. Um. So did y'all watch Diddy yesterday? Did y'all get caught up on Diddy? I didn't. I'm behind. I'm behind. I got to go back and watch. What's our boy name, y'all? Or mine? Okay, good. I gotta go back and watch Armand because I missed yesterday. But if Jane is off the stand and they getting ready to call somebody else, I'm gonna get up to speed on whatever they got going on with that person because I was so sick of Jane, it didn't even matter. I didn't want to watch Jane or hear about Jane testifying no more. It was the same story every day. The same story every day. Keisha live. I wonder what she's talking about. Okay, so I don't know if y'all know this either, but shout out to our girl Court with Keisha. She just told me that over on the Turtle Boy trial, he was found not guilty. They said, she said that he did a bench trial, and the judge found him not guilty yesterday. So he is free and clear. And y'all, opposing arguments is about to start. Get your pen, your paper.
You are unmuted.
Let's get it. Can you set this up? Thank you. I get in here, I need to see that flash drive.
Now we'll see
Here, I need my mouse too.
All right, so why don't I see counsel over here at sidebar? I've got my computer up.
Wait a minute. Is this Daddy O'Keefe? Is this Daddy O'Keefe in here sitting with the defense people? Yeah. Is that Daddy O'Keefe? Tell me that's Daddy O'Keefe. Who that is? Who that man? Okay, that's current Daddy. Okay, tell me something. Because where is Daddy O'Keefe at? Y'all know I don't know what the folks look like. Yep, yep, CB, it's Bryson. That's him. Oh, that's Daddy O'Keefe right there. Baby, I hope they flash the camera on him when they say not guilty. Cause why he's sitting with Peg and they look so disconnected. Uh, come through, Beta. Come through, Beta. Daddy O'Keefe is by his ex-wife. He with Peggy Leggy. Yeah, I'm so locked into these closing arguments. I got my pen, I got my paper. I am ready, honey. I really am. I am ready. Mm-hmm. All right, I'm just gonna go out here real quick, check and see if there is a stream going for Melly. Newsletter. How to stream? I'm absolutely looking for live on now. They say watch 24/7. That's cool and all, but I need y'all to show me where the Yes, y'all. I hope Karen get a not guilty too because this trial was a hot mess, and I heard that a lot of the jurors are young, and there may be some older ones in there, but the majority of them were young, and I hope them young folks can see clear as day when it comes to what happened with this trial. That man was not hit by a car. He was not. I'm scared for Karen, for real, for real. I would think that the defense is going to get to this though. They have a juror from the last time with him. Yes, I mean, we can only cross our fingers and hope that they see and understand that Karen was not hit by a car. I mean that Karen didn't hit John with no damn car. It's just crazy. It's crazy, and for them to be seeking justice, knowing damn well that the accident reconstruction folks say that the man wasn't hit by a car to still try and prosecute this case, it gives personal. Okay, it gives very much powers are at B or playing this. It does not. I'm gonna go ahead and sign out because I'm gonna mind my business. That's what I'm gonna do. That's what I'm gonna do. I'm gonna mind my business. I'm not gonna say nothing. Say nothing. All right, let's see what's happening over there with Diddy. Wait a minute. Change of venue request for Donna. Donna in court today? Yeah, Donna in court today. Yeah, Donna need to have a seat, baby. All right, let me go and get over here and see what's happening with the. Let's see what's happening over here with Diddy. All right. Let's see what's going on. The government's proposed witness for today does not know how guns were removed and piled in the security room. He has no personal knowledge. Can we exclude him? He's not an expert witness. He's a fact witness. When he was at the premises, the guns were found in the security rooms. They can cross-examine. There's nothing prejudicial. It's not about prejudice. The defense is going to object to every statement. That's the issue. I don't want jurors to see me objecting every time to guns. There is nothing illegal about these guns. Mr. Combs has professional security. Guns were in the safe. This witness is prejudicial. I don't care if they don't know where the Astroglide was. And that was from Combs' attorney. This is also Combs' attorney. But these are guns. Let them put on the agent who actually found guns. This witness should not testify. The government says this is how every law enforcement search is done. The property is secured before the search begins. They can ask, pronouncing it, ask. The judge says the defense would stipulate that the guns were there, right? You're asking this for the first time. I know the property well. I've been there many times. The security room has been locked. That is Combs' attorney. The judge says, can we find the person who did this? The government, may I step in? This is how Homeland Security investigation does searches. They have a team that goes in to make the area safe. They are not the experts in collecting evidence. Miss Foster can ask about that. I expect he'll say it was made safe. Combs is lower years. I'm not seeing how the guns are relevant if they are locked up. Guns are a very divisive issue. The judge says the witness can be asked about all of this. That's how we'll proceed. Combs' attorney. I had no idea he had no idea where the guns were found. He also says, I want to know where the guns were found. I don't want to play Russian roulette with guns. That's how Russian roulette is played, by this way. The judge says the agent can testify. Now, as to the jury, why can't we bring the jury out and get to the bottom of what the parties have raised? He said, I want the jury to come out. Oh, the juror, not the jury, the juror. So there's supposed to be an issue with one of the jurors in the trial over there with Diddy, because the government wants to strike one of the other black jurors. Now, as to the juror, why can't we bring the juror out today and get to the bottom of what the parties have raised? This juror is not a professional speaker. These were honest answers. I'm hesitant to raise this issue again and lead the juror to think we think he said something wrong. The juror's answers are innocuous. Innocuous. I said it right. We were concerned about his residency. Residency was resolved. The jury is diligent. Let's treat him with respect. What y'all trying to say? There is no issue with qualifications to serve. This juror met the qualifications at the time. It was vague enough that the answers can be reconciled. And then the government says the juror has said multiple things. They cannot all be true. Additional steps should be taken to protect the record. My preference would be to run it to the ground and hear from the juror. I expect we will hear a perfectly reasonable explanation. The judge says, but let me say, the allegation in the court. I just posted in the chat.
All right, so the court, please.
Oh, Bev done took her ass outside. But let me say, the allegation in court that the government is alleging is engaging in bias. There is no basis for that statement. Not in the jury selection, nor what occurred in the robing room. Is that what they call like the judges' chambers, the robing room? It is understandable they would raise it to the court. They're doing a whole lot of yapping this morning. Get to the witnesses. Now, Bev did all that talking yesterday. We're going to start on time. We're going to start early. I want the jury. We're going to have an early lunch. I want them to deliberate. Girl, you ain't even got... She is. If for her to act the way that she act, she should absolutely want this crap over with. Because that's what it is. Let's pop on over to NBC News. Maybe they'll give better context to what the hell is going on. So, court is now in session for day 23 of the Combs trial. Combs is in court today wearing light pants and a brown long-sleeved sweater. U.S. court judge said he wants to settle the government's objection to one of the jurors, though there doesn't appear to be enough evidence yet to remove the panelists. See, NBC giving the context. The judge revealed the issue could be about where the juror lives. The government earlier this week said that the panelists should be removed over lack of candor. My preference would be to hear from the juror, and it is likely we will hear a perfectly innocent explanation, adding that he wants to quickly resolve the issue and put it to bed. Yeah, see. Leave it to NBC to make sure we get good context. So we got some good context there. It's making me feel better. I'm also going back out to check NBC6 South Florida to see if we got anything popping on Melly's trial. They got anything up about his hearing this morning. For all my TikTok folks, have y'all noticed on TikTok we not getting any world news come through? We used to get world news in our algorithms. We're not getting any world news about what's going on over there in Israel or Iran. I can't remember which one it is. Yep, over Israel. It's over in Israel. Yeah, we're not getting none of it is coming into the feeds. I am going out searching. To you, I noticed that too. Yeah, we used to get world news. We not getting any world news updates on anything that's been going on. Not even the plane crashes. So it's like basically if you're not getting your news from another place, you can't really use TikTok to get up to speed on that type of stuff anymore. Oh, okay. So defense says we are concerned if we bring the juror back for the questioning, it might impact behavior during deliberations. The judge says we don't have to get to this right now. Mr. Combs, are you waiving the issue? He indicates yes. The judge, the question was, where do you live? An answer saying Bronx was accurate. One might move on, but it wouldn't raise to the level of removal of a juror. Here are some of the, and then the government says, here are, sure, some of the other cases are more extreme. Here, Rule 24C is operative. I don't really know what the hell they got going on over there, but yeah. All right. The defense wants to limit or bar testimony about the guns. The defense told the court that it'll likely object to questions about guns found during the raids at Combs during Combs' arrest. Combs' attorney called firearms a divisive issue that he'd rather not have on the minds of the jurors. I'm not seeing how guns in a security room are relevant to any of these charges. I would have to agree with you all there. Really would. I'm gonna go out here and see if I can find something from Melly. Okay, nope, I'm not seeing anything up here for it. Now the coroner's trial is on day. The coroner's trial is on day. I think we were still on day 1 of her trial. So I'm going to go back today. We'll watch that while we wait for Karen to Megan Jackson trial day 1. All right, give us something to watch because. All right, here we go. The daughter was off the stand, right? We stopped at the dip. The daughter was off the stand. The police officer took the stand. I think we were somewhere in here now. I'm gonna put a little sauce on this too, y'all, because we 4 days behind, so we got to catch up if we're gonna jump over to this trial next Sleep.
Yes.
Officer Perkins, where do you work?
I work for the Horry County Police Department.
How long have you worked there?
6 years.
What's your current assignment at the Horry County PD Brown Building?
Answered phone calls, took reports from citizens that walked in with problems that they needed a police report taken care of, and just general administrative type duties.
And when you say the ML Brown Building, what is that building?
I'm sorry?
What is the ML Brown Building?
ML Brown Building is the central precinct. It's the main precinct in the headquarters building for the county police.
Thank you. Were you working back on October 5th, 2020?
I was.
Did you come in contact with a woman named Megan Jackson that day?
I did.
How did that come about?
She came in to report a missing person.
Who did she report missing?
A gentleman by the name of Gregory Rice. She identified him as the father of her children.
Did she tell you when she last saw Gregory Rice?
I believe she spoke to him, if I'm not mistaken, by phone approximately 2 days before she came in, maybe 3.
And I may have asked you that. This was October 5th, 2020. Is that the date?
October 5th was when she came in, and I believe she said it was October 2nd at night when she spoke to him last on phone.
Okay. What was Megan Jackson's demeanor like when she reported Gregory Rice missing that day?
Quite frankly, pretty unremarkable.
He can't possibly know what she's feeling.
She just said what was the demeanor. He can testify as to what he personally observed.
Thank you, Your Honor.
You may answer that.
The demeanor-wise, it was pretty unremarkable. There was no major emotions, enough that I would have listed it in the report had there been something to list.
Okay. What did you do as a result of your meeting with Megan Jackson that day?
I wrote the report, entered it NCIC as a missing person, not in danger.
What do you mean by NCIC? What is that?
NCIC is the National Crime Information Center, where stolen cars, missing persons, and so forth get entered once they're reported to the police. And that way, if the person's found, say, in Los Angeles, they'll notify us that they found them and they're okay.
And does that conclude your involvement in this case?
That concludes my involvement, yes, ma'am.
No further questions for this witness, Your Honor.
Cross-examination.
Thank you, Your Honor. Officer, you said you retired after police service, of course. It says you came in, had no real noticeable emotion. Is that correct?
Nothing that was worth annotating.
Knock me down, like shock, maybe, kind of, nothing annotating. So no emotion relays. Are we trying to say that no emotion relays something?
What I'm saying is there was nothing displayed to me that I felt worthy of putting in the report.
Okay. So there's nothing remarkable then.
Exactly.
You just a person came in and filed a missing person report, just like they're supposed to do if a person goes missing.
Exactly.
Did you see Megan Jackson shoot Greg Rice?
No.
Did you see Chris Taylor shoot Greg Rice?
No.
No further questions.
Redirect.
No, sir, Your Honor. We ask that this witness be released from this hearing.
Okay. Mr. All right, you may step down and appreciate it.
Thank you, Your Honor.
Thank you. State your title, please.
Your Honor, the state calls Corporal Paul Johnson. And Your Honor, while we're waiting for Corporal Johnson to come in, I previously showed states exhibits 1, 2, 3, and 4 to the defense, and I believe they are admitted without objection.
All right, any objection to state's exhibits 1, 2, 3, or 4?
No, sir, Your Honor.
All right, state's exhibits 1, 2, 3, and 4 admitted to the evidence without objection.
Please raise your right hand and place your left hand on the Bible. Do you solemnly swear or affirm the evidence you're about to give the court in this case to be the truth, the whole truth, and nothing but the truth, so be God? Thank you. Could you just state your name and spell your last name for the court?
Paul Johnson, Johnsson.
And Corporal Johnson, I'm just going to ask you to turn your report over. If you need to look at it to refresh your recollection, we'll cross that bridge. Can you tell the ladies and gentlemen of the jury where you work?
Horry County Police Department,
And how long have you worked there?
a little over 18 years.
What is your current position with the Horry County Police?
I'm a detective with the Horry County Police Department assigned to the Property Division of CID.
So what are some of your duties and responsibilities in that position?
In this position, we investigate property crimes such as burglaries.
Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning, jurors. Good morning. So I have started far too many mornings by saying to you folks, I apologize for the inconvenience, having you wait around so long. I appreciate your patience. I didn't want to do that today, but I had to do that today. Everybody has worked so hard on this trial, the jurors, the lawyers, the witnesses, that everything has to be right before you hear it. So I needed to do that this morning. So I apologize. I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we were here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So as you know, it's time for closing arguments. And when I was a trial lawyer, I never liked it when just before closing arguments, just before I stood up, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. Closing arguments are not evidence. The lawyers aren't witnesses. And because they're not evidence, I need you to put away your notebooks because you can't take notes on them. But the reason it used to bother me is because I sensed that it made it sound like they're less important than anything else in the trial, and they're not. They're certainly a very important part of the case. And we've all noticed that you've paid very close attention to this case, and we know that you'll do the same to the closing argument. A couple of things I want to say, and you'll hear more about this in greater detail when I give you the charge. First is, you folks are the fact finders. So it's what you find from the testimony, your memory of the testimony. This has been a long trial, but your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, or constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden of proof. All right, the burden of proof is on the Commonwealth to prove beyond a reasonable doubt and to a moral certainty. And because of that, in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing arguments. I've given each lawyer an hour and 15 minutes, and I'm not going to stop them. So we'll start with the defendant's closing arguments. Mr. Jackson.
There was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well? He got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look. Sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him. He tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John. A gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look. Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. about 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. "You come in here?" Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert, think about this, not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scorti-Bello's words. Question. You did not include in your autopsy, in any fashion, any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scorti-Bello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scorti-Bello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. the taillight's completely lit up. That would be impossible. Dr. Andrew Rinchler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claimed the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory, why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it, to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, Huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question: can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffin's data, Ian Whiffin. John O'Keefe took 31 steps at a steady rate, about 83 feet, and then think about this, in a westerly direction. That would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffin himself conceded that he has reasonable doubts about the accuracy of John's location data. You remember that question and answer on cross-examination by Mr. Alessi. Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation, this is science, and it's irrefutable. It tells us that he was not laying outside in the cold, he was inside somewhere a little bit warmer. Ian Whiffin told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth La Posada, Judson Welsher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. La Posada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. La Posada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rinchler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scortibello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher, it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen in a house 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering. But here are the highlights. Proctor starts the conversation, quote, all the powers that be, one answers ASAP. He's getting pressure, obviously. Get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass. No ass bitch. She's got a leaky balloon knot. Leaks poo. 0 chance she skates. She's fucked. And up to this point, Michael Proctor had done 0 investigation. Nothing. Save talked to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Buchnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is supposed, every investigator is supposed to be objective, an objective fact finder. No bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life. The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from him. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses, and for bias. Not just any bias, bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single every single witness is who had access to that shirt and who had access to those taillight fragments, and the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those Solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the Solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm, because it was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer, smooth part of the housing. Not any shard, it was the outer, smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there. Just hung on. That same hair that moved in between photos in the Sally Port. Remember that? There were 2 photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the 2 photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing. The Proctor glass. Those 2 go together. The only 2 things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash. Didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said, in a very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? Wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth has presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, using location data on John's phone showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty, because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for a ledged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door at the garage? I was asking her about the front door, the side door, and the garage door, and her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Read. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with them for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins. But Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history. A dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabes. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was time-stamped by Celebrite at 2:27 a.m. A Google search that read, Hoslong to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia? Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses. Lying and perjury and admitting to it. A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was in real time. She was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling him everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession, it was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed, or anybody in that position, might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, I hit him. Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video, it's not on audio, it's not in a single police report, it's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, I hit him. You saw the video, multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered, he's bleeding, his eyelid is cut, his nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, shut up! Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house. Brian Albert's window. Jennifer calls her sister at 6:07. With all this chaos going on, no answer. Jennifer calls her sister at 6:08. With all this chaos and bedlam going on, still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moments that Higgins would be in that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch. That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop, and all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate. Is that a righteous test? Or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining him about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress-up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics, has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness, then we get to the sweatshirt. That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt. Not just to the witness, but to you. And asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole. Dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Reed. The truth is, Karen Reed is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reed because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Reed, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Reed of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Reed not guilty, not guilty, not guilty. Thank you.
Thank you.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying, and he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world. But to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard, she made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking at McCarthy's with John. She was drinking at the waterfall. Her blood was taken with samples of a retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, counter coup. You heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die. She was drunk. And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night, because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described for you one time, to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages, not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. Mr. O'Keefe drinks a lot, and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the mixed drinks. More shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober? And then at the waterfall, a shot, a mixed drink. Now, it was brought up the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Could we have slide 1, please? At the Waterfall Bar, when you see John O'Keefe come in, here's him barely greeting him. That's him and Mr. Higgins. Barely greeting each other. Reality sometimes is different than argument. This is a celebratory mood. Take that down, please. Celebratory mood. A bunch of friends. They're playing around, they're hugging, they're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In this celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said, that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
My alcohol intake's probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest at the time. It tasted just like old soda water with lime.
Slide 3, please.
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15. I mean, it was quiet. The roads were very quiet. You can see it on the videos. And I was going, when I've had a few drinks and I drive, I always drive extra slow. I know my alerts aren't as sharp as they should be. But I shouldn't have been driving.
Thank you. Do you think she drank when she got home? When they leave the Waterfall Bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Alberts home. He didn't sneak into the house in the cupboards and grab a glass. From the waterfall, you see him with a glass, and in it is a straw. Take a look at that picture. And now from 12/12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher, took the data from the black box and downloaded it so you can see the movements and the triggering events. And then Shannon Burgess, well, you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV. But what he did is he found a key, critical piece of this case that did not exist before. He found it recently. And it was that SD card. The SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the time and date and location coordinated for an impenetrable timeline that can't be broken. That's what Shannon Burgess did. And so we know on the way from the waterfall to 34 Fairview, Ms. Reed is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said it at the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze, high location data, as Ian Whiff would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement. And that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship, and then there's a trigger. There is a trigger on the way because they're lost, and when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Could I have slide 4, please?
Very close to the Alberts. In fact, when Jen was navigating John to the Alberts when I was driving, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating.
And so as they travel to 34 Fairview, under the duress of this crumbling relationship, fueled by intoxication, we have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that just a little, please. And it shows you with the healthcare data, it registers as flights climb, but it doesn't mean someone's climbing upstairs. What it means is there's an elevation, and he breaks down the data, the red, the green, if you could move down, please, Ms. Gilman. And then the bottom left, that's 34 Fairview. You can see, second by second, the circles of their route, even the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar Crest. And because of Shannon Burgess and because of Judd Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. Is a 3-point turn, and it all lines up with the cell phone. after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. DeSorga comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made criticisms like a Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We can have all the arguments we want. They're there, they're together. The data matches up perfectly, perfectly. And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for 2 reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest, at that intersection before it goes down to the right, they meet. They let Karen Reed go first. They fall behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life. And he's in that car. He's in that car for most of it. Because Ms. Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. And they didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Ms. Mason and Mr. Nagel said they were there about 5 minutes and then they go. It's not exact, but about 5 minutes, they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down? She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car, and we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside, or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves to 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high-frequency data because waves are shut off. Now it's more random, it's low-frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone at that point, you can tell exactly where John O'Keefe is. What he said is there was readings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved in the circles and come back. Location data is consistent with him never leaving the flagpole. But that in itself is not enough. But there's more. There is more. There is the healthcare data. There is the temperature of the cell phone battery. And so he moves to 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door in 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data, 20 seconds of his life, and he moves. And healthcare data registers as steps. It could be pacing, it could be a straight line, it could be shaking the phone. We don't know. We don't know. We don't know everything. We don't know every little detail and every little second. We don't have to. That's not doubt. That's not reasonable doubt. We know for that 20 seconds he's moving, and in that 20-second window, when he moves, he has his phone and he looks down, 12:32:09, he sees a text message from his friend, Jen McCabe. And he looks at the text message and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassion, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. Or like knocking on the door, like Kaylee said, getting the last word. She doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Miss Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Miss Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove, and what we have proven from the evidence in this case of second-degree murder, is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that, does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and if that conduct will create a clear and plain likelihood of death, then she is guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy. If somebody, maybe a teenager, someone young, impulsive, is on a bridge and they see cars going by and they have a boulder and they want to throw the boulder off, they're not looking to hurt anybody. They're not meaning to kill anybody, but they throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder off the bridge, and it comes down and lands on the car, and there's somebody, passenger, child, anybody in that car, and it then goes through the roof and kills the person in the car, did they intend to kill that person? No, they were trying to have a thrill throwing the rock. Did they have the malice to want that person dead? No, they didn't. But that would be an example of second-degree murder. When you take a boulder and throw it off a bridge, there's a plain and strong likelihood of death. When Karen Reed, in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him, and he died. I suggest to you that is second-degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton, it is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene, knowingly causing death. And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left. We know from the tech stream data that she drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers the 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with them. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever Mr. DeSorgo wants, he stops moving. John O'Keefe stops moving. Forever. Forever. Have slide 6, please. You'll get to see this more closely, and you can't probably see it where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred for somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed. Can't be attacked. ARCA, they did some crash test dummies. You know what else they do? Text stream data. There's nothing about that data that is uncertain. Nothing. Can you take that down, please? When Miss Reed hits John O'Keefe, collides with John O'Keefe, we don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back, but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back and he hits the back of his head, his basal fracture, he's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard. All over the yard. It's called debris field. And you've seen videos. You can't replicate the exact contact. You can't because you would need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris field, when a light is broken, it's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry. You know she's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare starts at 12/31/56. 12/32/04 to 12/32/12 is the data which is adjusted when you reconcile the clocks in Alexis. 12/32/09 is when Mr. O'Keefe closes his phone after looking at Jen McCabe's text. 12/32/16 is his last steps. Mr. Disorder says that red range should move a little bit, 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. If we could have slide 10, please. Could you play that, please? Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car. Now, as John O'Keefe sadly lays on the ground, abandoned, you're going to have to ask yourself a question for charge number 3, leaving scene knowing somebody was injured and then died. You're going to have to ask yourself, is there evidence that Miss Reed knew that she had hit him? Don't need to prove it for murder 2. Don't need to prove it for OUI manslaughter. But for the 3rd charge, Commonwealth has to prove beyond reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness. There was a guide. And that eyewitness tells us that she knew. And that eyewitness is Karen Reed herself. She tells you that she knew. Could we have slide 8, please?
Could I have hit him? Did I hit him?
How could that have been? I mean,
I don't know what that could have been. It was howling wind. I had YouTube blasting on the stereo, and I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come up and maybe trip or bend over to pick up his cell phone, and I ran over his foot, and then he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
When she left Fairview and left John behind, she didn't think he was mortally wounded. But she knew she hit him. She knew she hit him. And so when she made her way back home, not only did she leave debris field all over the front lawn, but she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger, you see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please. Can you play voice no one, please? The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone battery is compromised, so is John O'Keefe. And him and his cell phone alone on that yard. 66 degrees at 12:45. It is plummeting. Ian Whiffen's taking a phone and putting it in a freezer, not a same analogy. The idea that means that John O'Keefe was in the house, absurd. 66 turns to 61, it's 12:53. 48 unanswered calls from the defendant. He's not in at a party, he's not wrestling with Brian Higgins, he's not in a fight. If he's in a fight, his cell phone would be moving. There would be healthcare data, there'd be steps. If he got into the house in 20 seconds, and his cell phone is found under his body the next day, and how would he get back outside? There would be more steps, because this phone is working. The data is the data. There's nothing wrong with it. It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 2, please. Listen to this.
John, I'm dealing with a fucking kid. Nobody knows what the fuck you want, fucking pervert.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are? She knows. She knows. Nobody does know where he is. Except her. Except her. Why is she asking nobody knows who you are? She is starting to get panicked because she knows she hit him. Not suggesting she meant to kill him or for him to die, but she knows she hit him and now he's not responding and she's getting nervous and she's getting anxious and she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move after a little after 1 o'clock. She could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning. You can take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, where's John? She doesn't call Brian Higgins, has his number, has been texting with him. Hey, was John at a party with you? Did you see John tonight? She knows exactly where she is, and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand what she's saying. Call Jen McCabe. Call Jen McCabe. Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? When did he leave the house? What happened last night? No. She calls and says, I left him at the waterfall. I left him at the waterfall. See, now it's gone from panicked to self-preservation. I left him at the waterfall, and Jen says, left him at the waterfall? We saw you in front of the house. Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Carrie Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see. But someone's going to find him at some point. So she calls Carrie Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, Carrie, Carrie, Carrie. John's dead. I think he got hit by a plow. Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus for another big vehicle. I think he got hit by a plow. And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that for what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night in a blizzard out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom with a perfectly normal life gets drawn into this whole farce, and she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Carrie Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Carrie Roberts, separately at that time, answers the call, gets out of bed, drives to go help, because they have a common denominator, a common bond, John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judd Welch has showed you all of those demonstrations where you could see the unsettled snow in the back, and after the bump, you can see the pieces missing, no taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no break. It's a nudge. It's a nudge. But the taillight has already been broken because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes are on. You take a look, you'll be able to slow it down. You'll see the exact same piece is missing because it's back at Fairview. That's why it's missing. It's not there, it's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about, 5:35? 28 minutes. It's about a 10-minute ride. Where does she go in 28 minutes? Where does she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down, can't understand her, going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death? Carrie Roberts comes, take charge kind of person. She pulls him behind, she sees the broken taillight in Jen McCabe's driveway, and she decides she's gonna commandeer this. We're going back to Meadows, you're gonna follow me, leave the car, I'll drive. At this point, Jen and Carrie don't know each other. They've only met once. And they go back to Meadows. They obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Carrie Roberts, Jen McCabe, they're looking out the window. They can't see a thing. The snow, the blizzard, The weather, the darkness, they can't see anything. And they're driving and driving, and they decide they're going back to 34 Fairview, and this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close, they can see nothing. But the defendant screams, "Stop, let me out." And they look around and they say, "What? Let me out, let me out." She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him. She tells us. Slide 13, please.
Driving Jen's in the passenger seat. And I've described this to everyone, so you've probably heard this before, but John looked like a buffalo on the prairie. It was just a lawn and a heap that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you. A weird shaped lump in a blizzard, and you equate that to John O'Keefe? A weird shaped lump, not like a bush, and that is John O'Keefe? She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry and Karen, and she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what happens when they first move him around 603, 604? Ian with him. Data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd, hasn't moved. They start shaking him, you're gonna see, when you look at the records, that healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. And she plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. But remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the Albert House. The glass, well, you will hear in the clips, if we don't play it, you'll have all the clips with you. She talks about the fact that he took her glass. He took the glass. She says it. So the Albert House, they don't need to get the glass. He already has the glass with the straw that's later found on the street, by the way. That's what happens on an impact. Things move. The glass comes with him, lands near his body. Debris field moves past him. Shoe, hat, straw. Jen McCabe makes a call to her sister, and they say because it registers 29 seconds, a Cellbrite record is not the same as a call detail record. There is no evidence there was a conversation. No lights go on. There's no conspiracy. You can call somebody. It can ring. It can go to voicemail. They have no evidence, none, that there's a conversation between Jen McCabe, the person who was ripped out of her sleep to come help, and her sister for some grand conspiracy. And so what happens next is traumatic. Kerry Roberts and Jen McCabe see their best friend prone, lifeless, frozen, on the ground. And they're living this torment because somebody brought them into this. When they're trying to help John, there is not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time does anybody say, what time did he leave? I thought he went in there, not even a whisper of it, because it never, ever happened. When they find their friend John, he's not 20 feet off the side of the road like Mr. Rentschler or Mr. Wolf thinks. He's right there by the side of the road, close by the curb. Could we have slide 14, please? You can see there's Kerry Roberts' vehicle, and then on the left, you can see where they're working. Right off the road, that's not 20 feet. That is a clip, a stumble, and a fall. And remember, when Bellamy fell, there wasn't snow. It was just the beginning of a dusting. It was the cold, hard ground. Remember what Dr. Isaac Wolf told us about cold, hard ground? Causes this type of injury all the time. All the time. If we could go to slide 16, please. Remember the glass in the nose? The glass in the nose. See on the bottom left, that's where the Canton Police Department found the glass that he took from the car, from the waterfall. And then exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass, the glass that was found with Mr. O'Keefe, was found on the street. He didn't fall back 8-10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind, a trail to memorialize what happened to him that night. Remember the straw? I asked you to take a look at that picture. We're leaving the waterfall at 12:12, the black straw in the drink on the street. Collision, glass, nose, straw, back, hits his head. Could you play the clip on the left, please? 59.
So when John got out of the car at Brian Albert's house, he took my full bottle of soda, which is sitting in the cup holder.
169, please.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And it just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Thank you. 911's called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you've heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics of getting to work 2 hours early in the middle of the blizzard so that you're there on time so you can help people. These are the core of our community. Mr. Nuttall, this is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody, but to him it's another human being. This is his passion. Katie McLaughlin, first responder. This is not just a profession, it's her life. Yes, she knows Caitlin Albert. Do you think she went there that night at a party and set up a murder and came back? And so they tell you what happens at the scene. Some things hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever forget. And Timothy Nuttall remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him, she clipped him, she didn't think he was mortally wounded, she panicked, she can't come to terms with it, so she has to bring people with her to face it, and now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him, I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him, could I hit him, perhaps I hit him, that was earlier. Now, she's recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer. are in on a conspiracy? Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece or that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is, you have independent, core people who hear her say, I hit him, I hit him. And the attempt is to portray everybody as a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
So I must have said was, did I hit him? And I know I said I hit him, but did I really say this many times as law enforcement's claiming I said it?
Thank you. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those good people exactly what they had heard. She tells you herself she hit him. It's undeniable, it's unmistakable, it's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no coincidence that Mr. Nuttall and Ms. McLaughlin hear exactly that. She tells you. And Jen McCabe, when she's sitting next to or standing next to Ms. McLaughlin, she tells you that she saw or heard the same thing. Remember what happened to her on the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, the ironic thing is, you will see in a photo when Ms. McLaughlin, firefighter, was speaking to the defendant, Ms. McCabe was next to her. Ms. McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of this story was trying to help the defendant from incriminating herself. The irony. Could we have slide 9, please? This is the battery temperature. You're going to have a chance to look at it. If it wasn't so tragic, it is interesting. It is interesting if you like data. The 29, 12, 13, they're leaving the waterfall, 82 degrees, 12:22. In the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it's starting to go down to 72, 12:45, 66, 12:53, 61. And you see it drop and steady off at 1:36. Remember, cell phone battery under him. John O'Keefe either struggling for life or he's passed. And the blood's still warm either way under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Kerry Roberts goes over, picks up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next meeting, the temperature rises. That's not convenient. That's not a coincidence. That's fact. That's data. And then the phone is passed, put in a warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard that was under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? And not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. find out how long it takes for someone to die in the cold. And there's Miss McCabe in her winter jacket, soccer mom, trying to help. She has MS, her hands aren't working, she's trying to type in what's happening during that time. It's a frantic scene. She tells you that. The defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again. At 6:23, at 6:24. That's what this woman did that night, that morning. Not only for her friend, for her. For her. That's what she did. And what happens to her after? Because the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Hockomock Sports because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that is being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You usually can't delete that information. That's not a click and swipe like the good Dr. Wolf from Arca knows how to do. This can't be erased. But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way. Don't look at her. Look the other way. 2:27, look the other way. Don't look at what she did. Former Trooper Proctor, look the other way. Don't look at her. Every time they make those, oh, she got the glass from inside the Alberts, maybe in the basement. Look the other way. Don't look the other way. Look at the facts. Look at the data. And it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself. Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Try to evoke that primal reaction of disgust. I'm not saying you shouldn't be disgusted by the text messages. You should. You should. They're not defensible. I don't stand here and defend impropriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't give a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper McKennick was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't, but that does not change. It doesn't create a conspiracy, doesn't invent a dog, it doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there's a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce 3 of the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments. Not that there was any evidence of tampering, not that there was any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need a proctor to prove this case beyond a reasonable doubt. That's why I didn't introduce that evidence to you. Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house inadvertently, they didn't even know it, the dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He hasn't been near the car. And then the Dighton videos themselves, when you close it, you can take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please? .507. You can play any angle you want, but if you look at this angle, it's gone. You don't plant, it's already gone. You know where it is? 34 Fairview Road, on the Refield. January 29, 2022, 823. Look at the right-hand side. Look at the left-hand side. It's packed with snow. It's gone. It's gone. And the same thing when we do the videos, it's a different angle, a little smaller, but if you play that and watch the lenses go up and down and slow it down, you'll see it expands. It's gone. So when you have Dighton Officer Barrows come in here and try to tell you what he saw in the salad bar, couldn't have been it. You got to ask yourself, what interest does he have coming in here in this case? A lot of attention on this case, a lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in a conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite. And so he sits on the stand with a new story after a meeting. We don't know why. But then I show him that bottom right photo with the snow, with it missing, and I say, is this the way it looked? It's of course before the snow melts out in the salad port so that you can see it unexposed. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman, there's no plant, there's no Higgins at the salad port, there's no one tearing out pieces. In fact, remember I played you a clip and you'll have it where the defendant says, I was picking out pieces, it was crashed in, the bulb was showing, when I was showing Kerry and Jen, when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves, there's no ring video when she gets back. And so, now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here. It's on her profile, but she can't explain the methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. LaPosada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. How is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously, there is no science to looking at an abrasion and saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way. And so we have now the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scotty Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that, in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very common in car collisions. But that doesn't mean it didn't happen, because she, in 90 days, saw a fraction of the information. A fraction. And we know now, argument back and forth for days about lower body injuries, the suggestion is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some people can get plowed over by a car and have no injuries. Some people can get touched lightly and have more injuries. And there was the debate about no lower body injuries. Well, ARCA dispelled that in their dummy test, that you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time, in 90 days, that she doesn't have enough information to say consistent with a car accident doesn't mean there was no car accident. Let me talk a little bit about ARCA. I don't want to waste too much time with them. What expert who's supposed to come to you, they're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We've heard words like confirmation bias. It's objectivity. Mr. Wolf got on the stand, and before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text messages? What expert, what objective expert uses Signal, an encrypted app, to communicate about the case? Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8. That's all, and because it's a lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic. And he fought me over and over again. Did he seem objective that he was trying to help you? Because Dr. Renshaw came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welcher adjusted. Do you adjust it? And he tried to talk to me like I was making something up. His own colleague had to admit it. Now, it's funny, he admitted it before he got through his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point. And speaking of sequestration, remember Dr. Russell on her limo ride over? If Brendan asks you a question, make sure you ask for a transcript. Impede the progress. Slow down the questioning. Interfere. Sequestration orders is so there's fundamental fairness for all witnesses, not just some. And so what happens with Dr. Renshaw, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from his former employer. He said no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells us that he's independent and objective. I asked him about a luncheon, not a big deal, just ask him about it. And he says, I have a sandwich and I stand in the corner until I remind him that we got video footage from a documentarian and he's in one of the scenes. And then things change. So when you talk about objectivity and who to trust, they can come in and say, Judd Welcher said this and that. It doesn't make it so. Judd Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judd Welcher, Dr. Welcher, never suggested that. And his work on text stream data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably, proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. It was a relationship in decline, and he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk, she hit him, she left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injuries? Could I have slide 19, please? You bet they can. We don't know if this is the body position. We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curb that got lodged against the sneaker? Mr. O'Keefe then falls back, hits his head, counter coup, left to die. Thank you. Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Strengths, it is a plain and strong likelihood of death. You would never back down your driveway if your kids were at the end of the driveway. You'd say, what, are you going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless. She doesn't even have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not an it. John O'Keefe is not a body. John O'Keefe is not a buffalo on a prairie. John O'Keefe was a person, and he was murdered by Karen Reed.
Take that, thank you. All right, jurors, the next step is my instructions to you on the law. I'm not going to do that right now. You've been sitting for a long time. So I do have to tell you, even though you've just heard the closing argument, you cannot discuss this case even with each other. All right, so we'll send you back for lunch. It's going to be a shorter lunch. My instructions are long, and we want you to be able to get this case to start deliberations today. So I'm going to send you back maybe about a half an hour. Is that enough time for you folks? All right, so we'll give you a half an hour for lunch, and then we'll come back. I'll give you my instructions on the law, and then the jurors will go out to deliberate. I know there are 18 of you. We seat only 12 deliberating jurors, so 6 of you are going to be alternates. I can just tell you that, you know the odds, right? And I can tell you it's Mr. McDermott's least favorite part of his job is smoke. So we'll do that this afternoon. Do not discuss this case this in another half an hour.
Yeah, whew, she gonna come back and she gonna charge that their jury, and whenever she does that, then they're gonna get the case. She said that her instructions are long, so y'all just gotta let me know if y'all actually want to listen to her instructions. I absolutely do, because if she fumble or drop the ball, I want to be able to hold her accountable. I want to be able to go back and point out at the time which this woman was tripping. Now we didn't really talk about that jury form.
Counsel, can I see you just a second?
Now, we didn't really get to talk about that jury form, so I definitely want to hear her explain that form to these folks, because last time the form was jacked up and it ended in a mistrial. So there we have it. We are going to jump back over to Megan Jackson's case, the coroner affair murder trial over here on Court TV. We are super behind, so I'm gonna try to. I got a little bit of sauce on it right now, and hopefully we can at least get through today and maybe get through day 1 and maybe start day 2.
Larcenies, bank fraud, check fraud, forgeries, stuff of that nature.
How long have you had that position?
Just a few weeks.
Okay. What were you doing before that?
Before that, I have worked in CID before, investigating child crimes, sexual assaults, and also been a supervisor of environmental services in the past.
So let's talk about October of 2020. Which of your many positions were you in at that point?
I was assigned to Investigations Division, Special Victims Unit.
Is that what you were describing about crimes against children or sexual assaults, et cetera?
Yes, ma'am.
Would missing persons also fall under special victims?
Yes, ma'am.
So what were some of your duties and responsibilities in that position?
Missing persons, child assaults, some cold cases, mainly sexual assaults.
But what would you actually do?
In missing person cases, they would assign a case. You would make sure the patrol entered the person into TIC. Then you would go from there.
Sort of generally speaking, as a detective, would your daily tasks include, say, interviewing people, search warrants, things of that sort?
Yes, ma'am.
Okay. In October of 2020, did you become familiar with the missing persons case where the victim was Gregory Rice?
Yes, ma'am, I did.
Do you know, were you assigned as the original lead investigator?
No, ma'am, I was not. I was Assistant Detective Susie.
Detective Susie?
Yes, ma'am.
Okay. So, is there, you said you follow some sort of procedure, you make sure patrol has entered the person in NCIC. What other types of things would you normally do for a missing person?
In the beginning stages, you would also send out a department email in reference to the missing person with a photo. You would also contact the South Carolina Law Enforcement Division. They would do a poster on their Fusion Division, send out statewide as a missing person.
I'm going to show you what's been admitted as State's Exhibit 4. Is that the flyer that was prepared and sent out?
Yes, ma'am, it is.
Your Honor, I'd ask to publish this to the jury.
All right.
As part of this initial protocol, would you try to get the missing person's cell phone records or bank records or anything like that? How would you attempt to locate them?
Well, we would go out to their residence, make sure they are not home. If we still can't find them, we talk to family. And if we can't get a hold of any family, sometimes we'll do a search warrant at their residence and try to locate any cell phones, any kind of bank information to track them, stuff like that.
In this case, were you able to speak with the defendant, Megan Jackson?
We were.
And what, if anything, did she tell you at that point?
Myself and Detective Susie interviewed Megan at the police department. She stated she had dinner on Friday evening with the coroner. She then stated on Saturday that she went to the house. The victim was not there. She stated that she got a call for work and had to leave. She came back to the house. He still wasn't there, and that's where she contacted Horry County Police for a welfare check.
Based on that initial conversation with the defendant, did you and Detective Susie or other investigators get a search warrant for the victim's apartment?
We did.
Did you also get a search warrant for the phone records? And then I'll go back to the apartment.
I believe we did.
Okay. So let's start with the search warrant for the victim's apartment. Why would that be an investigative step that you would take?
Because we couldn't locate them. Sometimes inside people's residence, they keep bank records, debit cards, phone records, see what's in their vehicle, who they might have left with, phone records, just to try to figure out their last step before they went missing.
Did you, in fact, search the victim's apartment on October 5th, the same day you spoke with the defendant?
We did.
Did anyone assist you with that search?
Detective Susie and Sergeant Jim Chatfield.
At that point, did you have crime scene with you?
We did not.
And why not?
At that point, there was no reason to have crime scene. There was nothing out of the ordinary while we were searching that we would need crime scene for.
How did you get into the apartment?
Maintenance. The maintenance gentleman helped us in.
Can you give us just a very general description of the apartment?
It's a basic apartment complex. I mean, nothing. I do front porch, you know.
So it was a first floor unit?
Yes, ma'am.
How many bedrooms?
I think there was two. Not 100% sure. I believe there was two.
Was there anything? Did anything stand out to you during that search?
Nothing out of ordinary. A common apartment where someone would live.
Did you see any evidence of illegal drug use?
I did not.
And what types of things would you expect to see if someone was an illegal drug user?
Empty plastic baggies, empty pill bottles, spoons, lighters, stuff like that. We didn't witness any of that.
Okay. Did you, in fact, seize anything from the victim's apartment?
We did. We located the victim's wallet in his bedroom, on his dresser, as well as a folder containing bank information, and we located his keys. They were in between the cushions of a chair on the front porch.
So his keys were in between the cushions on the outside chair?
Yes, ma'am.
And now I'm let's approach first with exhibits 1 and 2. Do you recognize those items?
Yes, ma'am.
All right, start with exhibit 1. What is exhibit 1?
Dark brown wallet.
And what's exhibit 2?
South Carolina driver's license belonging to Greg Rice.
And was this driver's license in the wallet when you originally found it?
I believe so.
Is that how you, and just make sure you're talking into the microphone. Is that how you were able to identify this as the victim's wallet?
Yes, ma'am.
And then showing you exhibit 3, what do you recognize that to be?
Car keys and miscellaneous keys, keychains.
And is this a set of keys that you found stuffed between the cushions on that outside chair?
Yes, ma'am.
Did you find that usual or unusual that the keys were in a cushion, stuffed between the cushions in the outside chair?
Unusual?
I can't ask you a leading question, so I'm saying, was it usual or unusual?
I don't keep my keys there, but I mean, if someone was sitting there, they could have fell out of a pocket, I guess.
Did you locate the victim's car?
We did.
Was there anything suspicious about the car?
No, ma'am.
Did you, sorry, I didn't even ask your question, so. Did you speak with the defendant again that day? Or did you speak with the victim that day? Excuse me, sorry about that. With the defendant that day, you obviously didn't speak with the victim.
Yes, ma'am, we did at the Emma Brown Police Department.
Were you familiar with the defendant prior to this interview?
I knew where she worked. I'm not sure if I'd ever had any dealings with her or not.
She was familiar to you?
Her job was familiar. I don't know if I'd ever actually been on the scene with her, but I knew where she worked.
Okay. At that point in the investigation, was the defendant a suspect?
She was not.
You mentioned when you first spoke with her, she said she had dinner. Who did you say she had dinner with?
Initially, she told us in the interview that she had dinner with the coroner.
What did you think about that?
I thought it was odd that she didn't say the name.
Can you describe her demeanor during your interview?
Pretty calm, in my opinion. Not too nervous. Not nervous as other people have been during interviews like that.
Your Honor,
Not
I
worried.
understand that he is speaking to demeanor, but what is calm to me is very different than calm to him.
Overruled. Not allowed.
I'm sorry, so her demeanor seemed more calm than other people in a similar situation?
Just not worried would be my opinion.
What's the motion? Nothing further at this time. If you just answer any questions from Mr. Preston.
All right, cross-examination.
Yes, sir. Remind me what day you were out there?
October 2nd, I believe. October 5th. Remember the exact date.
October 2nd or 5th.
You mind if I look at my notes?
You brought some notes with you? Yeah, go ahead and take a look at it.
I believe it was October 5th. Sorry about that.
That's okay. How long were you out there?
Out at the police department or the
Out in the apartments.
apartments? No idea really. I mean,
Okay.
30 minutes, maybe an hour total. I'm not sure. It's been so long ago.
Okay. You don't remember that part? Okay. You don't remember how long you were walking around the apartments, you went inside, located items, is that right?
Did we locate some items? Yes, sir, we did.
And you located an item, you did enough of a search to locate an item on the front porch, right?
We did.
Now, during your searching around out there, 3 days after this alleged murder, did we see any bloodstains out there near the apartment?
Are you asking me?
I'm asking you, yes, sir.
You asking me if I saw any bloodstains the day I was there?
Yes, sir. The day you were there on October 5th, 3 days after this death.
I did not see any bloodstains when I was there, no, sir.
Okay. And you're an officer, detective. You saw those. That's something you make a note of, right?
If I saw bloodstains?
Yes, sir.
I didn't see any bloodstains.
Okay. While you were there, did any neighbor run up to you and tell you about the gunshots they heard 3 nights ago?
I don't recall anybody telling me about gunshots.
Okay. All right. While y'all were searching around, did you come across any bullet casings, shell casings?
I did not find any shell casings, no, sir.
Okay. All right. Did you know Mr. Chris Dontel?
Did I know Chris Dontel?
Did you know Chris Dontel?
I knew Chris where he worked, yes, sir. Not a lot of dealings with him, but I knew where he worked.
Okay. And where did he work?
The coroner's office, Oregon County Coroner's office.
Okay. Chief, mind just begging indulgence for 1 second? Anything you want to add? But all the questions, thank you very much.
Thank you, sir.
Thank you, Your Honor, very briefly. When you went out to Flint Lake Apartments, did you confine your search to the victim's apartment and car, or did you walk the whole complex?
Car in his apartment.
Nothing further.
All right, you may sit down.
And Your Honor, I would ask that he be released from his subpoena.
You bet.
I'm not going to hold on this one, Your Honor.
All right, I'll allow him to leave, but he's still subject to subpoena to come back.
Thank you, Your Honor. Thank you, Your Honor.
Second, call your next witness.
Your Honor, at this time, I would read 2 stipulations into the record, and there is evidence that would be admitted along with these. I can just have 1 moment. Your Honor, there has been an agreement by between the parties that if David Tennant were to testify during trial, he would testify that he is a manager at Abuelo's restaurant located at 710 Coastal Brand Circle in the Myrtle Beach section of Horry County, and that he was in that position in October of 2020. He would further testify that during October of 2020, Abuelo's had video surveillance inside of the restaurant. He is familiar with that surveillance system, and that while the date stamp on the surveillance was correct, the time was off by approximately 35 minutes. He would further testify that in October of 2020, members of the Horry County Police Department requested copies of the video surveillance footage from the evening of October 2nd, 2020. He provided them with a copy of the footage, a copy of which is contained on State's Exhibit 14. The video footage was not altered in any way. He reviewed that exhibit and did initial it as a copy of the surveillance video that was provided, and that was signed by myself and Mr. Case Burton. So I would ask that Exhibit 14 be admitted.
All right, is that stipulation?
Yes, sir.
Not to the admission. We still got to prove a chain where that happens.
But the stipulation.
This is accurate, Your Honor.
Well, Your Honor, I'm just asking for clarification. If this is a true and correct copy of the video that was provided, I believe we've established the chain.
All right. Well, ladies and gentlemen, there is a stipulation that's read to the court by Ms. Walter Now, the parties have stipulated to that fact, so that is not a factual determination that you will need to make. They both agree that is the fact, as in this case, that's what she read. All right, she's tendered State's Exhibit 14 into evidence. Any objection?
Yes, sir, Your Honor.
All right, State's Exhibit 14 submitted into evidence without objection.
Thank you, Your Honor. Next, there has been a stipulation, an agreement by and between the parties that if Hal Prickett were to testify during the trial, he would testify that he is the owner of Just Ask Hal, located at 201 Fresh Drive, Suite D in the Lowe's Food Shopping Center, in the Myrtle Beach section of Horry County, and that he was the owner in 2020. He would further testify that during October 2020, Just Ask Hal had video surveillance covering the exterior of both the front and back of the store, and he is familiar with that surveillance system. He would further testify that in October 2020, members of the Horry County Police Department requested copies of the video surveillance footage from the evening of October 2nd, 2020 into the morning hours of October 3rd of 2020. He provided them with a copy of that footage, a copy of which is contained in State's Exhibit 21. He would testify that while the date stamp on the surveillance was accurate, the time stamp on the footage was approximately 10 minutes off from real time. The video footage was not altered in any way. He has reviewed that exhibit and signed it to indicate it is a true and accurate copy of the surveillance video he provided. Again, that was signed by myself and Mr. Case Sprint.
All right, is that a stipulation that the defense agrees?
Yes, sir, Your Honor.
All right.
And I would ask to admit State's Exhibit 21.
All right, any objections? State's Exhibit 21.
No, sir, Your Honor.
All right, so stipulated, State's Exhibit 21 is admitted into evidence.
Your Honor, may we approach just about schedule?
All right.
Your Honor, there's been agreement going between the parties that if Mark Amos were to testify during trial, he would testify that he is a senior special agent at the South Carolina Law Enforcement Division, commonly known as SLED. He would further testify he has been the Automated License Plate Reader, ALPR, coordinator for SLED since 2018, and that in that capacity, he is a custodian of records for still photos taken by ALPRs in Horry County. He would further testify that he has reviewed the relevant stills contained in State's Exhibits 23 and including 34, through and including 34, and that they are true and correct copies of records maintained by SLED. And that is a stipulation signed by myself and Mr. Case Sprint.
All right, Mr. Priddy, that's...
Your Honor, again, let's yes, stipulate to the fact that they are relevant, that not to what they actually are evidence of.
Are you sticking what she read?
Yes, sir, that is fine.
Okay.
Yes, sir, thank you.
That's stipulated.
Thank you. All right.
So then my confusion comes from if they are stipulating that Senior Agent Amos is a custodian of records for SLED, and State's Exhibits 23 through and including 34 are true and accurate records kept by SLED, for which he is the custodian. What is the objection to their admission?
They're saying that they agree to your stipulation, disqualifications. They're just contesting that that exhibit shows what the state is saying it shows.
But that's what,
Yes,
but that's what the stipulation is. The stipulation is that Sergeant Amos would say that these are true and accurate stills from the LPRs, that he is a custodian of records, and that he has verified that these are all true and accurate copies of LPR stills.
And Your Honor, I stipulate to that part, but I don't stipulate to anything else beyond that. I don't stipulate to what she intends to use them for. I don't stipulate to anything. I stipulate to the fact that they are a real and accurate representation for Mr. Amos.
Which means that they're admissible.
And I'm not saying that
We're
we're
not
not.
getting into the admissibility.
Yes, sir. Yes, sir. Thank you, Your Honor.
You haven't even tendered them into evidence yet.
I just did, and the issue is,
I don't read back. Where did she say, I wish to introduce State's Exhibits 23 and through 34 into evidence? I get court reporters. I missed it. I'm sorry, and I apologize. I don't make a mistake.
if I misspoke, I apologize, but that's why I have them listed in a stipulation.
Your Honor. Yes, sir.
Hold for a second.
Yes, sir.
Court reporter check.
And that is a stipulation signed by myself, Mr. Baser, bars in Horry County. He would further testify that he has reviewed the relevant skills contained in the state's exhibits 23 and including 34, through and including the report, and that they are true and correct copies of records maintained by SLED. And that is a stipulation signed by myself, Mr. Baser.
All right, Mr. President, is that stipulation? That's fine. I don't see what you've ever said.
Then I apologize, Your Honor. I am following the same thing for all the stipulations. I would ask that State's Exhibits 23 through 34, which the defense has stipulated are true and accurate copies of records kept by SLED that have been verified by a custodian of records at SLED, be admitted into evidence.
All right, any objection?
Your Honor, I understand that they have to be, the expertise to be qualified, but I stipulate the fact that they are accurate and real representations. And Mr. Anybody sign off, but I don't stipulate to what they go to be introduced for.
All right, State's Exhibits 23 through 34 admitted into evidence on the defendant's good.
Thank you, Your Honor.
All right,
I apologize for misspeaking. No, I apologize. You're absolutely right.
All right.
Absolutely. Sort of some logistics. We're going to do the remote witness now just to sort of be done with that part of it.
All right.
Riley has made it so counsel doesn't have to join the WebEx meeting. If Your Honor wants the witness to be able to see you, you would join the meeting. I believe she sent you an invite. If so, she would ask that you turn off your speakers and your microphone.
Okay, my speaker's off. I mean, the volume's off. How do I don't see where I got anything. Where do I go?
Like a calendar? It should be a calendar invite. Is there, do you have?
I mean, I know how to get my virtual courtroom to the calendar.
So like on our Outlook, we have a calendar that shows everything we've got scheduled for that day. Do you have that on your Outlook email?
I don't have anything on now.
Like if I email you,
Yeah.
it comes up on Outlook, right?
Right. That's all right there.
Okay, and then, do you mind if I? Riley, I don't see it on the calendar.
She said, well, she sent it directly to the county court to this Vermont.
That's my administrative assistant. She's not here.
If you look at the records, I can do it straight up.
State can call your next witness.
Your Honor, the state calls Keith Yan, who will be testifying via WebEx.
Ladies and gentlemen, this next witness will be testifying virtually. Now, you are to judge this witness's credibility and the testimony the same way you would any other witness if the witness were present in person testifying.
Keith, can you turn on your camera? And the clerk's going to swear you in.
Please raise your right hand. Do you solemnly swear or affirm the evidence you're about to give the court in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Keith, can you state your name and spell your name for the court reporter, please?
D-A-I-T-H Y-A-H-N.
And where do you work?
I work for NDI Recognition Systems in Winter Strikes Authority.
What should your company do?
We develop, produce, and sell license plate recognition to law enforcement and homeland security.
How long have you worked at NDI Recognition Systems?
22 years.
And what is your current position?
Chief Operating Officer.
And what are some of your duties and responsibilities?
Responsible for the general day-to-day operations of the business, from sales to support to production, installations, all of our operationals. throughout the country.
Okay. Can you explain to the jury what a license plate reader does?
Sure, a license plate reader is a system devised of a camera connected to a computer that typically sits on the side of the road. The camera takes pictures of every vehicle that passes by and digitizes that picture and sends it to the computer that's attached. The computer then looks for the license plate in the picture, and it actually reads the text on the license plate and then sends that immediately via cellular modem to a server based at the state in the South Carolina Law Enforcement Division. That all takes place sub-second, so it's almost instantaneous. And then it stores that data in the server, where it can be used for either historical analysis or to match immediately against hot lists that are also stored in the server.
What do you mean by hot list?
A hot list is a list that's typically created by the FBI, the state, or a local law enforcement agency, and it's a list of license plate numbers and why they may be wanted for some purpose, whether that be a stolen vehicle, a stolen license plate, expired insurance, wanted person, something like that.
How long have license plate readers been in use?
They were actually developed in the mid-90s. They've been in use ever since.
Do you have knowledge of license plate readers in Horry County?
I do, yes.
And specifically, do Myrtle Beach and the city of Conway use LPR systems provided by your company?
Yes, both do.
Can you explain how an LPR system obtains the date and time? Well, let me back up. If a still is created from the LPR system, does that contain a date and time and location?
It does, I'm sorry. When that data is sent from the roadside computer to the server, it does include a color overview picture of the vehicle, a zoomed in black and white picture of just the license plate, along with the location, the camera name, the date, the time, and the GPS coordinates.
How does the LPR system get the date and time that it uses on those stills?
The date and time from those stills comes from the computer that's on the roadside, which is a Windows-based processor. So it uses Windows time synchronization, which means every 9 hours, every 9.1 hours actually, that system will go out through the internet to a time server, which is pool.ntb.org, which is run by Microsoft, and it will synchronize the time. So the time is synchronized through the web every 9.1 hours.
Did you get the first part of that website? Did you get that? Yeah. Can you just spell out that first part of the website that you just said that it goes to?
Sure. It's not an actual website you go to visit. It's just for time synchronization. But the name of it is pool, P-O-O-L, .ntp, as in network time protocol, .org.
Thank you very much. Have you been working with license plate readers since their inception, basically?
Yes, I have.
Okay. Based on your experience with the system, are the date and time included on LPR stills or reads accurate?
They are. They're such an important and integral part of the system that it's really important that we maintain accuracy there, which is why it's updated and synchronized every 9.1 hours.
Thank you. I have no further questions. Who's a question?
Coach, just one more, Steve. Go, Council.
In a moment, I'm going to have you answer questions from one of the Britons on the cross-examination.
Okay.
Thank you.
How you doing, sir?
How are you today?
Well, thank
you. Let me ask you about, do you know how many you see here today, how many LPR cameras there are in Horry County?
In Horry County, I believe there's right about 40 that are operated by our company, and then they have some operated by some competitors as well.
Okay. And how about any in Myrtle Beach, South Carolina? How many do you have in Myrtle Beach area?
Myrtle Beach, I believe, has 28.
And how many do you have in the Sockasty area?
I'm unfamiliar with that area, I'm sorry.
Okay. How about with Conway area?
In Conway, I believe there's right about 10.
Okay. All right. How about in Hainer? Do you happen to know about Hainer?
Objection relevance?
You happen to know how many there are in Hainer, sir?
I don't know anything about either.
Okay. Were you asked to look at any specific areas, or did you do a general search for this license plate?
I don't do any searches for license plates.
Okay. So what was your involvement in this case?
We developed and sold the system to the law enforcement agencies, and the systems are operated with those, within those jurisdictions.
Okay. So if there was a need to pull those LPRs in areas other than the ones that are in this case, would they have come to you to help pull those?
No, sir. They would have, those are all contained in the server and SLED,
Okay.
so they would have gone to SLED.
Okay. And so if we wanted to know and see where these vehicles were at other times, you're not the guy for that?
No, I'm not.
Okay. But based on what you've told us, there are many cameras throughout both the city and the county. Is that correct?
Sure.
Do you have any information at all about facts in this case?
No, I don't. I have no idea about this case at all.
Okay. Big reports and donors. All right. No further questions?
All right, ready?
No, Your Honor, but I would ask that Mr. Yan be allowed to return to work.
All right, any objection?
Yes, sir.
All right, very good. Thank you
Thank
very
you.
much.
Thank you.
Thank you.
All right, Stephanie, call your next one.
County State calls Jonathan Kelly.
Obtain surveillance to see if there was, if the defendant and co-defendant were on surveillance.
Okay. And were you able to get surveillance footage from Abuelas?
I was. We got footage from roughly 6 p.m. to 11 p.m.
And could you see the defendant on that footage?
I did.
Did you verify when you were out there that the date and time on the footage was correct?
Not the first day. So when we obtained surveillance on the 13th, we obtained, like I said, from 6 p.m. to 11 p.m. And I then took that footage back to the office and reviewed it. I remembered after reviewing it that we hadn't verified the timestamp with current time. So the next day on the 14th, I went back to the location, verified that the timestamp was 35 minutes fast. So you'd have to subtract 35 minutes from the timestamp on the video to get real time. I also noticed during that time that we missed an angle the first time. When we were downloading the footage, we were trying to just get footage where patrons would be. So we didn't download the portions related to like back of house, the chef's cook's area.
Okay.
So I observed a different angle as I was verifying the timestamp. So I also got additional footage that day as well.
You said you verified the date and time. How did you do that?
I looked at what it was displayed on the live feed, and then I looked at my cell phone and just compared the two.
So you found, I believe you said it was 35 minutes ahead?
Correct.
Okay. I'm going to show you what's been marked as State's Exhibit. May I approach, Hunter?
Yes, ma'am.
So State's Exhibit 14 has already been admitted in evidence. Did you get a copy of the video from Abuelas?
Yes.
Did you provide a copy of that to the solicitor's office?
Yes.
Have you reviewed that flash drive?
I have.
And is that a copy, a true accurate copy of what you provided?
It is.
Okay?
And I can tell that because it has my signature on it.
You signed it. Okay.
Yep.
Okay, I'm going to show you what's been marked as State's Exhibit 14A and 14C. Let's start with 14A. Have you reviewed that disc? You can take it out.
I don't see my signature on this one.
Have you reviewed?
But it does say clips from Abuelo's video, which is the footage that I collected.
So have you reviewed clips from Abuelo's footage?
Yes.
Okay. I'm going to show you 14C. Same question. Is that also a disc with clips? It's clips from 14.
Yes. Again, I don't see specifically my signature on this one, but it is also, the disc states that it's clips from Abuelos, which would be the footage that I obtained.
Okay, and have you reviewed clips from Abuelos?
Yes.
And are those clips fair and accurate representations of what's contained on Exhibit 14?
Yes.
Your Honor, at this time, the state would admit 14A and 14C and evidence of published to the jury.
Yes, sir, Your Honor. That we instructed the witness that he's not able to establish the proper chain of custody for it. There's no signature on those documents, on those discs to identify that he's the person who handled them. Don't have any way to know whether or not they've been tampered or if those are the ones that were procured for that day.
Your Honor, do you want me to respond?
Well, no, I mean, he says he's just basing it upon what's written on there.
Well, he said that he's reviewed the clips. The clips
But earlier on, he said
well,
he didn't know what it was, that he was reading as to what it is.
Your Honor, he's reviewed the clips. The solicitor's office just burns them to a disc from our system.
Exactly.
That's all it is.
So we'll use Exhibit 14.
Well, Exhibit 14 is voluminous.
Well, and I understand that,
We can,
but he did not properly authenticate 14A and 14C.
Your Honor, if it's okay with the court, we'll move on to a different witness. We'll have him review those, just so we don't have the jury sitting here watching a voluminous amount of material.
That'll be fine.
Thank you.
So for right now, I'm sustaining the defendant's objections to 14A and 14C as they have not been properly authenticated.
Okay, we'll have him review them, Your Honor, and get back to it.
All right.
Take a step down?
Yes.
Okay, thank you.
Wait a minute, wait.
Oh, I'm sorry.
No, cross-examination.
Thank you, Your Honor.
Your Honor, we were trying to pause this witness and recall him in a few minutes. Well, I guess we'll have to play the video then, I'm sorry. What we'll do is try to, Your Honor, let's sorry. Let's just-
Nah, they know they wrong for that. So basically, he was supposed to authenticate some surveillance cameras, but he's saying that his signature would have been on it. But when they looked at it, he like, that ain't my signature. So she's still trying to introduce it into evidence. And so the defense objected. It was and it was sustained. So they trying to get him off the like, you know, bringing another witness, but shit, they like, hold on, now we're gonna cross him. So child, what y'all finna do? Because the state need to pull it together.
All right, they want you to review that video.
Thank you, Your Honor.
Thank you, Your Honor.
Defense counsel wants to go over there while they review it.
Oh, sure, yes, sir. Thank you. Your Honor, the jury going to watch him review the video?
No, it's not in evidence. It cannot be seen by the jury at this juncture.
Thank you.
They won't be able to see it. Make sure that you won't project it. Well, you're gonna make some more questions.
You get that.
Oh, this one does have my signature on the bottom already, actually.
That's just asking. I got one first.
Oh, okay, yeah.
I'm just making sure.
All right, that's no testimony.
So now they showing him the video. I'm gonna try to. Okay, we back on.
Yes, ma'am.
Okay. Did you just step off the stand and watch State's Exhibit 14A?
I did.
Is that a copy of clips from the video surveillance you obtained from Abuelos?
Yes.
Is that a fair and accurate copy of the actual footage you obtained?
Yes.
Your Honor, the state seeks to admit 14A in evidence and publish to the jury.
Any objection?
Not to be difficult, Your Honor, but we still haven't established a chain of custody with this particular dish, Your Honor.
Your Honor, the chain of custody is not required for this is.
Let me make the ruling.
Okay.
Okay, you don't need to continue arguing, you entered it into evidence, they've raised their objection, now I've got to rule on their objection, all right? All right, State's Exhibit 14A is admitted into evidence over defendant's objection.
Thank you, Your Honor.
I'm going to show you 14C. Have you also reviewed 14C?
I have.
And is that a true and accurate copy of the video footage you actually obtained that day?
It is.
Your Honor, the state seeks to introduce 14C in evidence and publish it to the jury.
Any objection?
Mr. Your Honor.
All right, State's Exhibit 14C admitted into evidence without objection.
All right. Hey, Detective, I'm sorry, Sergeant Kelly.
Yes, ma'am.
We just watched State's Exhibit 14C. Could you identify anyone that you could see on that video?
Yes.
And who was that?
Chris Dontel and Megan Jackson were exiting the location. And again,
And were you familiar with Chris Dontel and Megan Jackson prior to obtaining this video?
yes.
How did you know who they were?
Chris Dontel was a deputy coroner, so he had been on several death investigations that I had been on, so just working relationship, had known him. And same with Megan Jackson, she was a transport driver for the coroner's office, so, or for a contracted company, I guess. But I knew
Did you
her.
recognize them by sight?
Yes.
You know what they look like?
Yeah.
Okay. And I'm sorry, I think I played the other one. Let's play 14A. So that one, I believe you just said was there bleeding.
Correct.
Can you tell me, you can still see the date, timestamp on there?
That says October 2nd, 2020 at 1957, which is military time is actually 7:57. But again, that's 35 minutes fast. So it should be maybe 7:22, if I'm subtracting that right.
Exactly. Athlete must run together. Okay, let's see. Let's play 14A. Okay, we just watched 14A. Can you tell me what you viewed on that video?
That was Chris and Megan arriving at Buelos about 50 minutes earlier in the previous video.
Okay. So they're out of order, but one is arriving, one's leaving.
Correct.
And what's the date on both of those?
October 2nd, 2020.
May I approach, Your Honor?
Yes, ma'am.
Your Honor, I'm going to approach with what's been marked as State's Exhibit 14B. Can you tell me what this is?
This is one of the other angles. This is a screenshot of Chris and Megan sitting at the bar at Abuelos on the same date, and the timestamp on that is 7:09.
Okay. And is that a still from the video State's Exhibit 14?
Yes.
Your Honor, this time State 6 introduced 14B in evidence.
Any objection?
Yes, sir, Your Honor.
State's Exhibit 14B admitted into evidence without objection.
Oh, Your Honor, we publish this to the jury.
All right.
Okay. Sergeant Kelly, there's a red circle on here. Who do you see sitting at the bar?
That's Chris and Megan.
And again, what time was that?
The timestamp on there is 1909, which would be 7:09. And again, you'd have to subtract 35 minutes to get the right time, I believe.
No, I'll probably show you what's been marked. State Exhibit 15, 16, and 17. And are these also stills from the video we literally just watched?
Yes, the time on this, or the number 17 is Chris and Megan leaving. Number 16 is Chris and Megan arriving, as is number 15. Those are just a few seconds apart.
And are those fair and accurate representations of video stills from State's Exhibit 14?
Yes.
Your Honor, at this time, State would seek to admit 15, 16, and 17 in evidence and publish to the jury.
Any objection? That's right, Your Honor. All right, State's Exhibits 15, 16, and 17 admitted in evidence presented.
So I believe you just kind of told us what they show, but just for the purpose of, look at it. Okay, just now that the jury can actually see the picture, I know we've seen the video, but just tell me what this Exhibit 15 shows.
This is Chris and Megan arriving, and as I'm looking at this, I also realized the timestamp on the actual footage there is that was 7:41 on the timestamp. The time that was showing on the video clip was covering that timestamp, so that's actually the accurate time.
Okay.
So the time that was showing on the videos that we watched was accurate timing. This is when I watched the video on the actual footage. That's the timestamp that's on there.
So there's the original time, correct? The time is over.
Yeah. So that timestamp at the bottom center of the photo is the timestamp that the footage shows from the surveillance system. That time that's noted on the right is the corrected time when you subtract the 35 minutes.
And I believe you testified that you verified that night that the correct time was the time in real life.
Yes.
Okay, let's have 16. Okay, so in this photo, who do you see in this photo?
That's Chris Dontel and Megan Jackson again.
And can you tell from this photo what Christopher Dontel is wearing?
Yes.
And what is that?
It's like a blue long sleeve shirt and some dark colored pants with brown shoes.
And what's the date and timestamp on this one?
This is October 2nd, 2020.
Okay, let's have Exhibit 17, please. Okay, and once again, what do you see in this video?
Again, this is when Chris Dontel and Megan Jackson are leaving Abuelos.
What's the date and timestamp on this one?
That is October 2nd, 2020.
And what's the accurate time?
The accurate time is 7:57 p.m.
Okay. Did you, after going to Abuelos and locating this surveillance footage, did you try to check any other businesses in the area to see if any additional surveillance footage could be located?
I did. I checked Coastal Grand Mall and some of the other businesses on the exterior of Coastal Grand Mall and the exterior perimeter road around Coastal Grand Mall, and I didn't find anything of interest.
You said you found nothing else?
Yeah, nothing of interest.
Did you and another detective check for video at or near the Lowe's Food Plaza on International Drive?
Yes.
Why were you asked to do that?
There was information that Greg Rice's phone tracked to that area. One of its last pings was in that area, so we were just checking businesses around that area for surveillance footage.
Okay. And what date were you looking for?
I believe October 2nd and into October 3rd, I believe.
Why was that date reported?
That was the last day that his phone pinged, and that was I believe, the last time that it was reported that he was seen.
Okay. Were you able to locate any surveillance footage from that shopping center?
Yes.
Where were you able to get it from?
Howell's Computer Repair.
Okay. Where's that located?
I don't know the exact address, but if you're looking at Lowe's front door from the parking lot, it's to the left, but in the same structure, like the same plaza building.
Okay. Have you reviewed that video?
I have.
And does that video have a date and timestamp?
It does.
Okay. We've learned from our stipulation that timestamp is 10 minutes fast. I'm going to approach with what's already been admitted in evidence as State's Exhibit 21.
Yes.
Just to see. Is this a copy? Did you give a copy of the surveillance to the solicitor?
The copy was, I'm not sure how necessarily it was delivered, but again, my signature's not on this particular.
This one's already been admitted into evidence.
Okay.
The copy we make copies of what you provide.
Okay, yes, so, yes, it was submitted to evidence.com and evidence the way that we would normally submit it, correct?
Okay, so when you say you submitted to evidence.com, is that uploading it to a computer software system?
Yes.
So you're not, I'm just clarifying, you're not actually delivering flash drives to the solicitor's office?
Correct.
All right. Did you also I'm going to approach with what's been marked as Exhibit 22. Yeah. Okay. May I approach her?
Yes.
All right, so this one, I believe has your initials, so let's look and see.
Yes.
Okay, so have you reviewed that disc and verified what it is?
Yes.
And what is that disc?
This is clips from the footage obtained from Howell's surveillance camera.
Okay, and is this a fair and accurate representation of the clips that you obtained?
Yes.
Your Honor, at this time, the state seeks to introduce Exhibit 22 in evidence and publish in jury.
Any objection?
Yes, sir, Your Honor.
State Exhibit 22 admitted in evidence without objection.
Okay, so, play 22, okay. The calls for one second, just for clarification. Sergeant Kelly,
Yes, ma'am.
when you obtained this video footage, did you obtain footage other than just the defendant? That's inartfully worded. What I'm asking is, when you obtained it, did you obtain a specific time period and not just footage of the defendant?
Yes, correct.
Okay. So are what we're looking at here clips of the portions of the footage that relate to the defendant Megan Jackson?
Correct.
Okay, so let's play this. Okay, so first of all, just pause it. What's the date and time on this video?
October 2nd, 2020.
And can you read the timestamp?
The time says 23:17, and if I remember right, I believe that's 10 minutes fast. So it should actually really be, in layman's terms, it would be 11:07 p.m.
Okay, and as we watch the video, can you tell us what you see in the video?
As we watch it,
Yep,
Okay.
as it happens, try to narrate.
All
We
right.
can pause it when we need to.
there's a silver Ford Explorer, which I know is what Chris Dontel drives as a county vehicle, and the van that pulled in is also what I know Megan Jackson drives for transport.
Okay.
Here we see Dontel getting out of the vehicle, and we'll see in a second his clothing is the same that he was wearing at Abuelos.
Does he have anything in his hand?
He has a
May I have an objection, if I can stay, please? All right. I don't believe it's appropriate for the witness to narrate the evidence. This is the evidence that presented to the jury. The jury is able to see it. It doesn't need to be a narrator for it. And I don't think that's appropriate testimony.
Would you like me to respond?
Please.
Your Honor, the witness is narrating the video because he's a police detective, and as part of his investigation, he reviewed this video and located the defendants and their cars and the defendants themselves on the video. This is a way the state frequently presents evidence. It's nothing out of the ordinary. I don't see anything wrong with the defendant stating what he sees on the video. He can either do it while it's playing, or I can have him do it when it's not playing.
No, I don't think it's because it's been done in the past makes it something you just can do today, Your Honor.
All right, I'm going to allow the testimony, but ladies and gentlemen, it's up to you to decide factually what the video shows. If you find that the witness's account does not coincide with what you view, then you're to disregard his testimony. I'll allow him to testify as to what he says the video shows, but ultimately it's going to be your decision to decide what the video shows. All right?
Thank you, Your Honor.
Okay, you can continue to narrate.
so he's carrying a bag.
Okay.
At this point, he appears to open the rear hatch to the van and puts the bag in the rear area of the van. It's now roughly real-time 11:10. Chris Dontel opens and closes the rear hatch of the Explorer. And just a few seconds later, still roughly 11:10 p.m., the van drives out of the parking lot.
And you may have already said this, but did you recognize that van?
Yeah, that's what I know Megan Jackson to drive.
In what capacity did she drive that van?
A transport van for transporting dissidents or decedents.
Let's play the second clip. Okay, pause for 1 second. Okay, what's the date and time on this video?
This one is October 3rd, 2020, and the timestamp shows 12:25 a.m., just after midnight, but the actual time is 12:15 a.m.
And what do you see parked there in the parking lot?
The Explorer is still there, and now a van is pulling up. It's the same make, model, appearing to be the same transport van that Megan Jackson is known to drive.
Jimmy, what are they doing?
What is now open to be seen?
So who wanted to see me? I'll see you at sidebar for just a minute. No, Chris, yes. Yes, I'm sorry. Some space here, please.
Hold 1 second.
Okay, Paul.
Rise to the jury.
Jim, now you're gonna have to go through all of those to pick the alternate out.
You okay with that?
Oh, okay. Okay. All right, jurors, I'm going to give you the instructions now in the law. But first, I want to thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purpose of reaching a verdict, but before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case.
The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law. That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part one of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard, and heard in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case. You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made, are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answers to the questions and the exhibits are evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. You should evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable, or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for this purpose. Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability, and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider three questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involved factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact John O'Keefe, Ms. Reed, Michael Proctor, Brian Higgins, or others alleged to have authored or created them. If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case. Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it. Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinioned witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give the exhibit. Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the underlying evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that's sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now that completes the first part of my instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder. Now, I just want to tell you that our Supreme Judicial Court has promulgated jury instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right. So murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to Ms. Reed, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as well, and I'll explain those to you as well. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all 5 elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense, with that lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and you work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care, that is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, and the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI. So the third indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other four elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay. Thank you. All right. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are 18 of you. To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law in Massachusetts is that only 12 jurors can deliberate. Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted, because as I've indicated, it's important that we have extra jurors in case of an emergency. If we did not impanel extra jurors and a juror became ill, or for some other reason had to be excused, we would have to try the whole case all over again with the new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, and in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case? I'm going to ask you if you would be foreperson in this case. Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree. So, all right, so I skipped the line. When you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using. in returning your verdict. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment.
Okay, don't know what happened there. Something went wrong with that web page. So I'm just reloading it. Back Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible, and that is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your role as the jury is to determine the facts in this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are.
Neither is it possible for me to provide you with a transcript of the testimony. If you send a question to me, I'll respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. Generally, we will not answer a question or take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case, I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought into you, and you can decide whether or not you want to stop your deliberations during lunch or continue and deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at sidebar, but I'm required to see counsel at sidebar.
This woman up here with this blank face, she really irks me too. The one right there next to Peggy. Yeah. And Daddy O'Keefe, he got a nice little distance between them. Good elbow room. How you pick the foreperson before picking the jury?
May I?
Yes.
The foreperson before picking the jury.
Could the juror sitting in seat number 13 step down and take your place as an alternate? Could the juror sitting in seat number 7 step down and take your place as an alternate? Juror 6, could you step down and take your place as an alternate? Juror 17, could you step down and take your place as an alternate? Juror 2, could you step down and take your place as an alternate? And Juror 8, could you step down and take your place as an alternate?
All right. Yes, please do.
Could I have the court officers raise your right hands? Do you swear that you will keep this jury in alternates in some separate but convenient place until they agree that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they agree, nor suffer them to disperse until they have discharged their verdict, except by further order of the court, so help you God? Thank you.
All right, so members of the jury, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy and not prompted by any facts except those that you've heard here in court during the trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may retire and deliberate your verdict.
Jared, make sure you take your notebooks with you, please.
Y'all, the jury has officially been charged and said, "Hey, Miss D, where you been all day, girl? We missed you in this chat." I was thinking about you earlier. I said, Miss D ain't in her in the chat today. What is she doing? Whatever it was, I hope that you had a good time. But the jury has officially been charged and they are heading out. I guess Bev is going to tell them to stay within 5 to 10 minutes of the distance.
I'm going to see counsel one more time.
Here she goes, another sidebar where there is absolutely. That girl in the blue looked constipated. Like, what's wrong with her? She looked absolutely constipated. But if juror number 6 was the Commonwealth's plant, they out. They out of there. So that ain't something we got to worry about. If that was a plant. She do. Like, what's wrong with her? I don't know, child. Well, we're going to bounce ourselves back on over there to... Oh, okay. She said she was packing. We're going to go back over to Megan, because I do want to hear the boyfriend take the stand, y'all. I ain't going to hold you. Jonathan Kelly is still on the stand. He is one of the police officers who got the surveillance camera that shows Megan with her boyfriend.
There I see, again, same outfit, Chris Dontel exiting the driver's seat, going into the rear hatch of the van. Pulls out what appears to be the same bag from earlier. It was hard to see there, but in between the two vehicles, you could see a person walk from the passenger side of the van in between the vehicles, and the clothing was dark. So I assume Megan Jackson. It's consistent with the clothing she was seen in Abuelos. Chris Dontel loads the bag back into the Ford Explorer and gets into the driver's seat. Now, real time, it is roughly 12:17 a.m. and the Explorer is driving off. And now the van is left behind.
All right, let's move on to the next clip. Okay, pause it, cancel it. Okay, what's the date and time here?
This is October 3rd, 2020. Timestamp says 1:27 a.m. Real time would be 1:17 a.m.
You can press that. And what do you see parked in the parking lot there?
Megan Jackson's van is still parked there. There's a silver Ford Explorer arriving, which is consistent with Chris Dontel's county vehicle. Again, we see coming from the passenger side, a person appearing to wear all dark clothing. That's consistent with what I saw in the Abuelos video that Megan Jackson was wearing. She appears to get into the passenger side of the van. Chris Dontel grabs the bag out of the Explorer again, walks to the van.
They looking at the verdict slip, y'all, so I swooshed it back.
Oh, thanks. Oh, Jesus. You sworn in first. Counsel, you can keep doing that. Mr. Rose, can you raise your right hand? Do you solemnly swear that you will keep that jury in some separate but convenient place until they agree, and that you not suffer any person to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse and to charge their verdict, except by further order of the court, so help you God? Simply because you weren't in the room. Thank you. Is the Commonwealth content with the verdict slip?
Almost content.
So, Your Honor, I understand that you've rejected our proposed verdict slip.
So everybody else can sit down. Mr. Yannetti can stand.
Thank you. I understand that you've rejected our proposed verdict slip. Our concern with this verdict slip is that there are 4 options for, actually more than that, 7 options for guilty verdicts, 1 option for not guilty. And we're concerned that this is too confusing for the jury. So we are asking that there be not guilty options for each of the charges, including the offense charged and each one of the lesser included offenses. We really ran into the same issue last time. I think what complicates it is the fact that there are 2 theories for 2 of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying that. I'm saying that it makes things very confusing, and that's why we believe that it cries out for some not guilty option, given the amount of options for convictions on this verdict slip. So
Okay.
we would again ask the court to adopt our proposed verdict slip.
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Mr. Yannetti? I have not found any. I've looked.
there's not a lot of case law out there even to support this verdict either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
And I mean that
So,
with all
so
respect.
that's fine. So your rights are reserved. Does that help you?
Right, well, all we can do is object to it, and you make,
Okay.
you make the decision.
Okay.
Judge, the last couple.
If you find authority for that, let me know.
We'll do.
Okay.
The last couple of things, judges, that we were provided with a clean
Laptop?
computer laptop, thanks. With a clean laptop. Defense counsel had a chance to, or at least defense had a chance to look at it, and I think that's fine. But
All right, so we'll send that in with the exhibits. I need to go edit my charge to fix all the typos.
And then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
Thank
All
you.
right, thank you.
All rise for the court, please.
I think that's bullshit. Why would you show them? Why would you give them an option to say not guilty 7 times, but only give them one option to say? Why would you show them? Why would you give them an option to say not guilty 7 times? I said that backwards. I'm glad that my TV is talking back to me because I clearly just said that backwards. Why would you give them an option to say guilty 7 times and not guilty once? That makes it very, very difficult, and it makes it confusing. That shit ain't common sense. But if she get convicted on anything, they're gonna throw that shit out because their verdict form is trash, and they need to pull the jury if they come back with anything. Whatever they come back with, the jury need to be pulled.
Places the bag in the van, closes the rear hatch. Then he gets into the driver's seat of the van at timestamp 129, but again, 10 minutes fast. That would real time would be 119. And then the van drives off, leaving the Explorer behind again this time.
All right, final video. Final video. All right, so what's the date and time here?
This is October 3rd, 2020. Timestamp says 8:25 a.m. It's actually 8:15 a.m.
Okay.
You can see the Explorer, Silver Explorer, is still parked in the same spot from the last video. Doesn't appear to have moved. And arriving is a minivan, again, consistent with Megan Jackson's van. It's a little difficult to see, but in between the palm fronds there, you can see, again, clothing matching what Chris Duntel was wearing in the Abuelo's footage. He goes into the rear hatch of the van, grabs a bag that appears to be the same bag that he's moved back and forth. Timestamp now says 8:28 a.m., which is actually 8:18. You can see the Ford Explorer that Chris Duntel drives is leaving, and then also the van is leaving behind it. And they both leave the parking lot.
Just to be clear, are those merely clips of the entire surveillance video that you retrieved?
That's correct.
So if the jury wanted to watch, they watch the entire.
They could.
And all those videos that we just saw, were the two vehicles that you pointed out, the Silver Explorer and the van, consistent throughout?
Yes.
And I believe, you said you recognize those?
Yes. They both appear to be consistent with what Chris Duntel or Megan Jackson would use at work.
Let's move on to, did you respond to the Myrtle Beach funeral home?
Yes.
Where's that at?
I don't recall the address, but it's just south of Faro Parkway and Highway 17 bypass in the Myrtle Beach section of Horry County.
And were you able to determine whether Myrtle Beach Funeral Home had an alarm system?
Yes,
Were you able to determine if it was functioning at the time of this murder?
it was functional, but the owner had kept it disabled because he was getting too many false alarms. So he didn't want to pay the false alarm fines.
So,
So there was an active system, but it was not being utilized.
what about surveillance footage? Were you able to get any surveillance footage from the Myrtle Beach Funeral Home?
No, it did have surveillance system at one time, but the information that we obtained was that it had been rendered non-functional during another review for a different instance.
So were you able to obtain any surveillance footage from the Myrtle Beach Funeral Home?
No, it was not functional at that time.
Okay. What, if anything, did you learn about who has access to the Myrtle Beach Funeral Home?
We asked the funeral director and learned that
The defense has asked a number of witnesses if they had, a number of law enforcement witnesses, if there were any reports of shots fired the night Greg Rice was killed. In your experience, are there always calls when shots are fired in Horry County?
not always.
No further questions for this witness, Your Honor.
All right, cross-examination. All right.
Was that the extent of your involvement, sir?
In relation to the death investigation, yes. I believe I obtained a search warrant for maybe some GPS locations related to a possible bond violation, but I'd have to check my notes to remember the exact details.
Did you, as was here today, do you have a general understanding of what's been alleged to have happened?
Yes,
Do you understand that there's an allegation that Ms. Jackson and Chris Montel were having an affair?
correct.
They're having an affair, right? And
Bless you.
Bless you, Your Honor. And as part of that, some of what we've seen here in terms of Lowe's, you notice every time they left Lowe's and they were going towards Megan Jackson's house, what vehicle were they in?
I don't know which direction they went when they left the parking lot.
Oh, you didn't have that was not part of your investigation? You don't know where they left and went to?
No, I don't.
Okay. Would it make sense to you that if they were going to take their vehicle, drive to Megan Jackson's house, where Erica Dontel, the person who is in the dark, lives nearby, that they would take Megan Jackson's vehicle so as not to reveal the
Objection, Your
affair?
Honor. Calls for speculation.
That could make sense, yes.
Okay. And so all of the shuffling around of vehicles makes sense for people who are engaged in an affair that they're trying to hide. Do you agree with that?
Yeah.
You'd also agree with me, wouldn't you, that Megan Jackson appears to be wearing the same clothes at Roy Lowe's as she was at Lowe's?
Yes.
Would you agree with me that we don't have any audio from any of this footage?
That is correct.
Okay. So we don't know what they were discussing at Roy Lowe's?
Correct.
So any effort to determine what they were discussing based on the evidence you have presented would just be speculation, correct?
Correct.
Do you likewise agree with me that people who are, again, having an affair still have to eat? Is that right?
Absolutely.
And so just being at a restaurant together in and of itself is not any kind of proof of any kind of negative or improper activity.
This is correct.
You probably also agree with me that in these times when there's no report of gunshots, that'd be a little less likely in an area where there are 10, 20, 30, 40, 50 residents?
The more densely populated an area is, I would suggest the more likely somebody might call. Horry County's a rural county though, and you are allowed to hunt in the rural counties, the rural areas of Horry County. You're allowed to shoot as long as you have proper backstop and things like that. So it's not uncommon to hear gunshots in Horry County.
How about at Arrowhead, sir? Flint Lake Apartments. How many people live out there?
It's densely populated there, but there are wooded areas, and there's the intracoastal waterway right there as well.
So we can agree that Flint Lake Apartments is densely populated with people who presumably can hear.
Yeah, correct.
And not only is Flint Lake Apartments in and of itself densely populated, the area driving in and out of there is densely populated with homes.
Correct. There's also woods in that area as well, but yes, it's Myrtle Beach, so it's more metropolitan than, say, Green Sea or Aner.
Okay. What's the goal?
All right.
No further questions. Thank you very much.
Thank you, sir.
Briefly, Your Honor. I believe Mr. Britton asked you a question about the videos and you see a lot of shuffling back and forth, and is that consistent with people having an affair? In your 15 years in law enforcement, is that shuffling around also consistent with people involved in a homicide?
It could be. It could be for any number of reasons. I don't know how to elaborate more. It could be for any number of reasons, but that could be also another possibility.
Okay. Nothing further, Your Honor.
You must have that.
Thank you.
All right, ladies and gentlemen, we're going to go ahead and take a short break, give you an opportunity to stretch your legs, get something to drink, leave your notepads in the jury box, do not discuss the case, and do them on yourself. We'll take about a 15-minute break, and we'll come back in a second. Notepads, no one else's notepads. State, you call your next witness.
Thank you, Your Honor. The state calls Donna Sue Souls.
Raise your right hand and then place your left hand on the Bible. You can look right here. Do you solemnly swear or affirm the evidence you're about to give the court in this case will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Just right there, watch your step. Get you to state your name and then spell your last name for the court.
Donna Sue Souls, S-O-L-E-S.
Thank you, Your Honor.
Yes, ma'am.
Thank you. Thank you for coming in today, Ms. Souls. You don't have to give us your address, but do you live in Horry County in this general area?
Yes, ma'am.
And do you have family in the area?
My whole family.
Are you familiar with an area called Pitt Landing?
All my life.
And I'm going to show you what's been admitted as State's Exhibit 51. And just a minute on that. Do you recognize that area?
Yes.
Is that the Pitt's Landing area?
Yes.
Your Honor, at this time I'd ask that this be published to the jury.
What exhibit?
51, Your Honor.
All right.
Let me shrink a little bit. So, and it's on the same on all three screens. So is this the area that we refer to as Pitt's Landing?
Yes, ma'am.
And if you can just stand up and point out on that map where Pitt's Landing is. So that little kind of bare area. Okay, thank you very much. Do you recall going to that area the night of November 7th of 2020 into November 8th?
I do.
And what was it about that date that makes it, what's the first thing about that date that makes it stick out in your mind?
My grandma passed away that day, and we went to the funeral. And, well, we always go catfishing down there, like, since we were kids. But we left the funeral that day and up on 378 and come back. And my little brother was with me, and asked if we want to ride down there and check it out, so we did. And then us not living far from there, we went to the house and got our boats and we went back down there, just kind of clear heads for today.
And when you went there, were you going to set out catfish lines?
Yeah.
Okay. Now, this is something that you taught me when the first time we met. So can you tell the jury, what do you do when you set catfish lines?
You set bush hooks, like you kind of tie the lines to the tree and put whatever you can fish with on there, and then you go throughout the night and check them.
So are you actually in a boat on the river when you're doing this?
Yes.
Okay. So did something happen that night as you were setting catfish lines or checking catfish lines that brings you to court today?
Yeah, I came to the third one, and the smell, like when we went to go to set the line, I smelled the smell.
When you say you smell the smell,
It was an awful smell. Like you couldn't bear it. It was, actually I threw up, vomited.
okay. And what did you do once you smelled that?
Well, we knew it had to come from somewhere, and you look around and really didn't see anything. Then it was getting dark then because it was earlier, and so it kind of shined a light, and I saw it looked like a tarp, but it was like on the wood line, and which is where I shined it. And so we went back to the hill and we didn't mess with that one. I went back to the hill and I told Ronald, and Ronald's my little brother, and I said, there's something about that that's not right. Like I know it's a smell I've never smelled in my life, and I've done a lot of fishing, a lot of hunting in my life, and it's any kind of animal I've ever smelled, it's nothing like it. It had no comparison. And so when we went back to check the lines, and got to the third one, I told him we needed to check and see, just see what exactly that was. And we got closer, and as we got closer, the flies and it was the smell, we were both throwing up. And so we went on to it, got kind of close up to it, and Kaylee, which was my little brother's girlfriend, she was in the boat with us, and it was her first time catfishing. And so before we went there, my friend Jamie was on his other boat, which was my best friend's husband now. So we got Jamie to come, and Kaylee got on the boat with her before we went back over there to check out and see what it was.
So let me just stop you there for just 1 second. And Your Honor, I neglected one exhibit that I believe will be admitted without objection. State's Exhibit 48.
Objection.
Sorry, Your Honor. No objection.
All right, State's Exhibit 48, admitted in evidence without objection.
I'm showing you State's Exhibit 48. Is that what you first saw?
Yes.
Okay. Your Honor, I would ask that State's Exhibit 48 be admitted and it's admitted, that it be published to the jury.
All right.
So is that what
So you can see kind of like from looking at it, like it looks like a tarp, something of that matter, if you're on the boat out there and you were shining the light.
And then Your Honor, I would ask that.
And the smell to go along with it, like you kind of knew that's where it had to be coming from. So I told Jamie to come and let her on the boat. And then I was scared too, to be honest with you. And the water never scares me. But when I saw that and the smell, I knew it was something that couldn't have been right.
So did you guys get closer?
Yes.
Your
And
Honor, I would
then
ask that State's Exhibit 49, which has already been admitted, be published.
All right.
And is that a closer view
Yes.
of the tarp? And I think before you said that you noticed quite a bit of insect activity. Did you guys eventually go even closer to that?
Oh, absolutely.
Okay. And what did you do once you got closer?
I have a yellow extendable paddle that I keep in the boat, and I opened it, and Ronald pulled me up to it, and he was back there driving my little boat at the time. But I got up there, I took that paddle, and I kind of, because of course I wasn't gonna touch it with my hand, I didn't know, but the smell was so bad in between you getting sick and doing it, but it was so bad, I couldn't take it on. The closer we got, the more sick I got, and then he got sick too. So he was like, I don't know if I can do this, and I was like, well, we got to figure out what it is. So we did leave, and we went back to the hill, and we had a fire, because you go throughout the night checking these hooks. And Ronald, I don't drink, but Ronald does drink, and he had a couple of shots of Fireball, and I said, I was sitting on the tailgate of the truck, and he said, sis, what is it? And I said, Ronald, you're not gonna, like, you've been drinking, you're gonna think I'm crazy if I tell you this. And I was like, something's
Your
nagging.
Honor, yeah, she's just right on about hearsay.
Okay, it's the same, can't get into what anybody else said. Just here, you cross-
Sorry.
That's okay.
I was explaining that. I was telling him, you know, and that's why we went back. And I was like, something's nagging me and telling me something right about it. Like, we need to go check it out.
So based on that, did you then get even closer?
Yes, then when we went back, I took the paddle and put to, like, if you're looking at it, the left side. And
Your Honor, if I could publish previously admitted State's Exhibit 50.
All right.
And so did you, I'm sorry, did you get that close?
yes,
Okay. And you were talking about a yellow extendable paddle. What did you do?
I took the left-hand side of it and kind of like went to pick it up. And like the water, it was slippery. Like, because, you know, like it had, whatever it was had been there. And the paddle slipped, and then I put it back and I tried to pick it up, but it was kind of heavy. So Ronald come up, and my little brother again, and he helped me. And when we did it, it was around like this part of the legs.
Okay, I'm sorry. And I just have to describe it for the record. Okay, she's pointing here,
And-
kind of around the knees.
So yeah, like the bottom arc part is what it looked like. And but there was a ratchet strap around it, around like the side. But when we pulled it up more, and then so I said, I didn't know what it really was, but it looked like it could have been, you know, something. I thought a body. But then I went to the other side, and like you couldn't see the round part in the water. But again, I couldn't pick it up by myself because I mean it had been there, and I knew there was weight to it, and it was kind of scary. And so Ronald helped me once again, and we put the paddle and did it, and it was around the head. Like you could actually see the round part through the tarp.
Now, you talked about seeing a ratchet strap. Did you ever see anything attached to the ratchet?
Cinder blocks.
A cinder block?
Mm-hmm.
In addition to kind of trying to lift up both ends, did you do anything else to determine what was inside the tarp? Did you have a knife with you?
Yes, when we saw the round part, Ronald said we need to call, and I said, yeah, we do, but you don't, if you call them and say you found a body or you didn't really know what it was, I was like, there's gonna be so many people out here. And again, it kept bothering me. I was like, we got to, you know, he's like, let's just make sure. So being that the head was on that side, or what we thought was the head by the circle part, I said, Ronald, you're gonna cut like towards the top. You could tell it was a cypress stump. Like we go fishing out there all the time. So whatever it was caught up on, it looked like part of that cypress stump. And he made the first slot, and you could, like the paddle and the light from the one I had a light on my head, it kind of looked like the jeans in the maybe muscle, like, so it made me think it had been there a while, but then you couldn't exactly know for sure that's what it was.
Did you cut another spot on
Yes, on up. I said, don't cut, like, we're not gonna cut like closer to the head, like, cause you don't wanna see that, like, that's enough to live with. And you could see like the shirt and like the rib cage.
Nothing further at this time. I believe Mr. Case Britton will be questioning you, so just please answer any questions he has.
I'm so sorry that you had to be the one that suffered homicide. Actually, sorry about your funeral earlier that afternoon. You said that you were out there early evening?
Yeah, well, catfishing, you set lines like an hour before dark. Or you set the hooks, and then you go throughout and just check them, because you gotta have them back up an hour before daylight.
Okay, look, I'll be honest with you. I've got no idea about catfishing. Last thing I know about catfishing, you stick.
Well, I know you're trying to get the time. You're trying to get the timeline, you know, like because it was later on that night.
Later on that evening.
But you go and you set them, and that's what.
And one can talk at a time. We've got a court reporter that has to
Oh,
take
okay.
everything down. All right? So ask your question and then allow her to answer.
Yes, sir. Thank you. Correct. I'm just trying to establish a roundabout timeline.
Right.
You said you were at a funeral.
Yeah, my grandma.
And I apologize for that. We just lost our grandfather a couple months ago. Daytime, 2 o'clock type funeral?
Yeah, it was earlier that day.
Earlier that day, okay. So y'all were going around and, did you say your son, your stepson?
No, my little brother.
Little brother, okay, I'm sorry. Just want to go clear his head, get out on the water.
Well, we always go catfishing down there, and I mean it's like an every other weekend thing. And on the way back, we was like, let's go down there and check it out and see how the water is. And then we had buried grandma, so it was like, that's perfect time. So we ran to the house. Like I said, we don't live far from there. So we hooked to the boats and went back.
Great place to get out, put your head on the water. Do you have firsthand knowledge how that tarp got there?
No.
No further questions, Your Honor.
Ms. Wright?
No, Your Honor, I would ask that Ms. Souls be released from her subpoena.
Any objection?
No, sir, Your Honor.
All right, very good. Thank you very much. State, can call your next witness.
Your Honor, the state calls Captain Heather Wilson.
Officer in Danville City Police Department.
What is your current assignment?
Currently, I am a captain and I am assigned to the 2nd Precinct, which is also referred to as the South Precinct, and that is in the Socastee Burgess area of the county.
What was your assignment before that?
So before I was promoted to captain, I was the supervisor in the crime scene division.
Did you hold that position both as a lieutenant, since you were just promoted to captain?
Yeah, so it would probably be easier if I spent almost 10 years in crime scene as a detective, and then went to homicide division and worked as a detective, was promoted to sergeant, worked on patrol, and then came back to the crime scene division as a sergeant. And then ultimately I was promoted to a lieutenant in a lieutenant in the crime scene section, where I stayed until I was promoted to captain.
Thank you. That was much better worded than my question. So both as the sergeant and the lieutenant in crime scene, what types of responsibilities did you have?
So ultimately the responsibilities were the same. As far as overseeing the crime scene division, I would also go and help or assist with scenes. I would take on my own scenes. I would help with training the new crime scene investigators that would come in, reviewing reports, fingerprints, processing of evidence, ordering, and then just normal business type things that you would think in any job.
If I'm doing my math in your timeline correctly, you were working in the crime scene unit in October, November of 2020?
Yes.
Okay. As part of your rotation in the crime scene unit, did you become involved in sort of globally the missing persons that turned into a homicide of Gregory Rice?
I did.
Directing your attention specifically to November 8th of 2020, did you respond to a call for a call for service regarding human remains that had been found in the Little Petey River?
Yes, I did.
Did any other crime scene investigators go with you?
Yes, at that time we had another crime scene investigator that I was training. He was brand new, and he responded as well.
Great. Were you familiar with that location prior to responding this night?
Yes.
So if we get, Your Honor, 51 has already been admitted and published. I'd just like to show that again. Is that the area to which you responded?
Yes, it is.
When you first got there, can you just describe what you saw? Were there other people there? What was sort of going on?
There were other people there. Marion County Sheriff's Office was there, and ultimately I wasn't sure exactly where the possible remains were located. So I got in a boat with DNR to go around to view, because as you can tell, this line, it shows a line between Horry County and Marion County. So we were trying to figure out what jurisdiction was going to be taking over the case.
Okay, so that's the line that's going through the river. That's the county boundary?
Yes, it is.
You said you got into a boat and went out?
Yes, I can make it.
Your Honor, I believe State's Exhibit 148 will be admitted without objection.
Made State's Exhibit 148, admitted in evidence.
Showing you State's Exhibit 148, is that actually a photo of you going out towards the body?
Yes.
Okay. Your Honor, I would ask that Exhibit 148 be published.
All right.
And I believe, who's that in the boat?
Wearing the orange, that's me, and then the one with the mask is a DNR officer, and I don't remember what his name is.
So there were several agencies who responded out to this call.
Yes, there were.
How was it decided who would, jumping ahead, was that object eventually retrieved from the cypress stump?
Yes, it was.
How was it decided who would go out there to make that retrieval?
So the Marion County deputies ended up talking to the Marion County Sheriff, who said, Horry County crime scene is already here, so will they mind go ahead and processing the scene for us? Usually smaller agencies like Marion County would call in SLED to come and work cases, or an agency around them that had the resources to assist. So ultimately, it was decided that we would assist with the processing of the evidence. And like I said, I did go out with DNR to see what we have, because again, they're trying to describe it to me, but I got to be able to see it so I know what resources to get, which then our fire department was called in to bring their boat so that we could utilize their boat to pull the victim out of the water.
Can you describe what you saw as you approached this object in the river?
So the first time when I went out, I just saw the tarp, as you can probably see in the last photo you just looked at. It looked like a gray tarp, and that's what you could see floating at the time. Yes, thank you. So that is exactly what I saw the very first time that I went out. And then I began to see more as I went over the second time. I don't know if I'm jumping ahead, but the second time when I went out with DNR, I was in this little John boat, and the other investigator was in the fire department boat. And then I could see that it was a person as they were pulling the tarp and the human remains out of the water.
Now, I prefer, these have already been admitted and published. So I'm showing you states exhibits 48, 49, and 50.
Yes.
Okay. And so did you recognize these photos?
I do.
Okay. And did you get as close as the photo in States Exhibit 50?
I did, yes.
So if we could put up States Exhibit 50 again. So I believe you said that the fire department boat was used?
To retrieve? Yes, to retrieve, yes.
Were you present in that area when the body was retrieved?
Yes, the DNR officer and I were still kind of parched over at that same tree that you saw in the last photo. And that was just because there's no way that we were going to be able to pull the victim onto the little John boat without flipping that boat. So we were still there so that I could visually see and direct the new investigator on what to do.
What did you see as the fire department was pulling the body out of the river?
I could see parts of a human body. I could see additional tarp. I remember them saying it's hung on something and them trying to figure out why they couldn't load the victim onto the boat. And then ultimately they found ropes, and it was connected to a cinder blocks. So they just kept pulling and pulling, and were finally able to get the cinder blocks as well on the boat.
Okay, thank you. So I'm going to, so no objection to 52. Your Honor, the state would move to admit States Exhibit 52 and 54. I believe that would be without objection.
All right, States Exhibits 52 and 54 admitted in that, no objection.
So if you could look at States Exhibits 52 and 54 and tell me if that accurately reflects, before we publish it, accurately reflects what you saw.
Yes, it does.
Your Honor, at this time I would ask that they be published. All right. So let's start with Exhibit 52. Can you describe what we're seeing in States Exhibit 52?
Yes, so the blue tarp, I believe that's probably one of the firefighters' arms that you're seeing. And then the blue tarp is what the firefighters use to put down on the front of the boat so that they can pull the victim up onto the boat. And the gray tarp is what the victim was in. And then you can see it's like a green tie strap is what I would refer to it as. And you should also be able to see in the corner up here, it's harder to tell in the photo, but in person you could tell that it was a human being.
And then if we can go to State's Exhibit 54.
And this is the rope that I was referring to, and the cinder block that was attached and wrapped around the victim.
After the body was brought to shore, can you give us a more full description of sort of how the body was wrapped?
Yes, so as the fire department was pulling the victim onto the boat, the victim moved a little in the wrapped tarp because of the weight of the cinder block. And they weren't prepared for a cinder block. They were just thinking that it was just somebody wrapped in a tarp. So the victim was moved a little when they pulled him up. But then when we got to shore, so the fire department boat with the victim, and then myself and the DNR officer followed behind. We got to shore, and then we were able to take photos of the victim who was wrapped in the tarp and then wrapped in a couple of blankets. He was dressed, and there were zip ties and the rope that you saw, as well as that brick.
Where before you removed the tarp, where did you see the zip ties?
On the outside of the tarp, if I remember correctly. I would have to look back.
Okay. And eventually was the tarp taken off of him?
It was.
Can you tell us what you saw?
For the victim?
Yes.
So the victim was wearing a hooded sweatshirt, pants, shoes. There was a pack of opened cigarettes in his pocket, a lighter in his pocket. The victim was badly damaged, so it almost looked like he was somewhat mummified. And it was hard to tell, but there did look like there was a couple of small holes in his shirt. And but again, if someone is in water for a long period of time, it would be difficult to see small wounds.
Was there were you able to see a lot of blood?
No.
Did that surprise you?
No, it didn't, because again, there was no gaping wound or a head laceration, or there was no large holes. So you wouldn't really see a lot of blood. Even if there was a large hole, you wouldn't expect to see a lot of blood if someone was submerged in water for a while.
Okay. Did you or the other crime scene investigator who was with you take photos of the tarp once the victim was removed?
Yes, we did.
Your Honor, the state would ask to admit Exhibit 55, I believe, without objection.
Yes, Your Honor, without objection. State's Exhibit 55, admitted in evidence without objection.
Is that a photo of the tarp after the victim was removed?
It is.
Your Honor, I would ask that this be published.
All right.
55. And so what, if anything, did you notice about the tarp, or can you just describe what we're seeing?
So the tarp was very sandy from being in the water and then also hauling them onto shore. And the zip ties are at both ends of the tarp. So you can't really see it in this photo, but at the top end, there's a zip tie, just like there is on the bottom. And you can see the extra part of the zip tie on the bottom, right next to the eyelets.
Did you or other investigators collect that tarp?
Yes, we did.
What did you do with it?
So everything that was collected right then, I'll go back. It was decided that this was going to be Marion County's case. At the time, we didn't know who the male was that was deceased. So Marion County was taking the case. We collected everything and signed it over to Marion County Sheriff's Office. Ultimately, after the autopsy and we were able to determine who the victim was, we then went back and took custody of all of those items and brought them back to the Horry County Police Department.
I'm going to approach with State's Exhibit 131. Do you recognize what this is?
I do.
What is it?
So the box is titled Gray Tarp from Victim on Scene. And this is my handwriting, and this is how it was ultimately packaged. Do you want to open it?
Yeah. Your Honor, with the court's permission, since it's not published yet, may I just walk around the witness stand so she can open it?
May I see it, Your Honor?
You can just, if you recognize it from there. Yes. Preston, do you want to come up before I publish it or ask that it be published?
Yeah, Your Honor.
No objection. Your Honor, sorry, I lost my train of thought. Was 131 admitted? I would ask that 131 be admitted. I believe it's without objection. Sorry. And then I would ask that it be published.
No objection. So I was on. 131, admitted in evidence, without objection.
Okay. Thank you, Your Honor. And is the tarp wrapped in, I guess, protective plastic?
It is.
And why is that?
Due to, it's a biohazard, obviously, because someone that was deceased was inside the tarp, which is inside the biohazard bag.
Okay, so if you could just lift up the wrapped tarp and explain how you recognize that it is the tarp that was recovered that day.
So it is labeled with the case number and the description that it is a gray tarp. Every piece of evidence has a tag, which is here, this white tag. It feels like a tarp. It's my handwriting. It's sealed on the back with the evidence seal with the date and my initials. Inside the box with my handwriting, the date and the initials.
You mentioned that there were zip ties on either end of the tarp.
There were.
Were those also recovered?
Yes.
And same thing, they went initially to Marion County and then back to Horry County?
Yes.
And Your Honor, I believe there's no objection to the admission of State's Exhibit 127 and 128.
Any objection?
No, sir, Your Honor.
All right, State's Exhibit 127, 128, admitted in evidence, without objection.
Are those the zip ties that were removed from the tarp?
Yes.
Your Honor, I would ask that these be published.
All right.
And then showing, I believe you said when the tarp was sort of unwrapped that the remains were wrapped in other material?
Yes. A couple of blankets.
Your Honor, I would permission of State's Exhibits 129 and 130 without objection, I believe.
Any objection? Yes, sir. State's Exhibits 129, 130, admitted in evidence, without objection.
And you could look at those and tell me if those are the blanks or the sheets that were recovered from the victim's body.
Yes.
And again, how do you recognize that?
So they have the labels up here at the top. Like I was saying, every piece of evidence has a label, but I just recognize it from collecting it and packaging it.
Your Honor, I'd ask that Exhibits 129 and 130 be published.
All right.
Okay, and then you also, give me my work back. We also talked about, I know, I didn't say this morning. A cinder block that had been secured around the victim.
Yes.
Was that seized and taken into first Marion County and then Horry County evidence?
Yes, that's correct.
No objection.
Do you want to come up?
I got that back.
Do you want to come up?
Sure, I'll come here. Okay, 20 number is that?
36, Your Honor.
Would you like me to get? I know you're tougher than me. You're tougher than me, sir.
Your Honor, I believe that it's being admitted without objection.
Any objection?
Yes, sir, Your Honor.
State Exhibit 36, admitted in evidence without objection.
And again, Your Honor, with your permission, we'll go on so that Captain Olson can open it. I'm just trying to wrap it there. Yeah, take it. Yeah.
I wrapped it like a Christmas present.
Okay, now, if you can take that out and just tell me if that is the cinder block that was recovered from the victim. And if so, Your Honor, I'd ask that it be published.
All right.
This is,
Okay, so if you can, I'm making you carry it now, so if
Okay.
you can just kind of open up the box and show.
Your Honor, may I
Oh,
walk back?
I'm sorry, Your Honor, that's Exhibit 56. 56, not
56?
56, not 36.
State Exhibit 56, not 36, is admitted in evidence without objection.
Your Honor, may I walk down with it? Thank you. Here's the zip block. Everyone can see that?
I'll take the whole box back.
Well, can I want this one?
Can you put it
Back on my box. And then,
and then put it on the table?
Yep.
Thank you very much, Captain. Did your involvement in this case continue after the recovery of, well, let me back up. Were those remains eventually identified as the remains of Gregory Rice?
They were.
Did your involvement in the case continue to include a search or processing of the Myrtle Beach Funeral Home?
Yes, it did.
At the time that you did that search, did Horry County have any definitive information on where a crime scene might be?
No.
Do you, and if you don't, that's fine, do you know what directed attention to the Myrtle Beach Funeral Home?
I probably did then, but I don't remember now what actually directed us in that direction.
And basically, as crime scene, you kind of go where they ask you to go and process the scene.
Correct.
So did you, on November 13th of 2020, participate in the execution of a search warrant at the Myrtle Beach Funeral Home?
Yes, I did.
What were you looking for there?
So ultimately, we were looking for any type of physical evidence that would suggest an assault occurred there. So like cleaned up blood, body fluids, any evidence of a shooting, investigation, just to see if something possibly occurred there. So we were looking for body fluids, blood evidence, firearm casings, projectiles, that type of stuff.
Were you ever able to definitively determine that there was a crime scene there?
No.
You said that you were aware that the remains had been identified as Greg Rice. Did you know how did you ever learn how he had been killed?
Yes, we were advised that he had been shot during autopsy. There were multiple projectiles found in the victim's body that were collected.
Were those 22 caliber bullets?
I believe so.
In your, I guess it'll be about almost 26 years of law enforcement, have you received training at each one of your departments?
Yes, I have.
Has that training included training on firearms?
Yes.
Have you in fact carried a firearm as part of your profession for the last...
Wait a minute, y'all. I'm gonna pause this for a hot second because I just saw a picture of the verdict slip and I want to share it to get y'all opinions if y'all think it's confusing. So this is the first page of Karen Reed's verdict slip. Now this is this is like the official slip, y'all. So it says the first offense of murder in the second degree in the above case, you can either say she's not guilty or she's guilty. And this was a unanimous decision. They dated, and then the foreperson would sign it. Then when you go to the second one, this is where it's interesting. So the second offense is manslaughter while operating a motor vehicle under the influence. They could say, nope, she's not guilty of the charge or any of the lesser charges, lesser included offenses. Or they could say she's guilty as charged. Or they could say she's guilty of the lesser of that, and then the lesser of that, and then the lesser included charges. So looking at it, it actually don't seem as confusing as the defense made it seem when they argued it. But tell me if y'all disagree or not. Because if I saw this, I'll be like, nope, this person is not guilty of the offense charge or any other lesser included offenses. Like, that's what I would think. And then there's no need for me to go through this because I already said no at this top piece right here. And then this last one, the same as the first one. Leaving the scene of an accident resulting in death. Either I think she's guilty of it or I don't. So it seemed clear to me. What y'all think? Y'all think it's clear? It don't seem as bad. It don't seem as bad as they made it on the while they was arguing.
Yes, I have.
So are you familiar with different types of weapons and different calibers of weapons?
Yes, I am.
What, if any, significance did it have to you that the victim had been shot with a .22 caliber firearm?
Objection, Your Honor. This is stated about, I don't understand what this is. Hey, I don't understand the question.
I'm sorry, could you repeat that?
Certainly. Based on your years of experience, what, if any, significance did it have to you that the victim had been shot with multiple times with a .22 caliber firearm?
So a .22 caliber would leave a very small wound or a small hole, regardless of what the bullet is penetrating. Therefore, it would be more difficult to see.
I'm not objecting, now that I know where the answer is headed. He's trying to qualify her as some kind of expert, it appears, in forensics. She didn't do the autopsy anymore. She's trying to skip around that and have her testify about bullet holes and what a bullet hole would leave. It's not her area of expertise. Thank you, Your Honor.
You can continue your answer. I believe you were saying that it would be smaller holes, smaller wounds.
Yes. So with over 15 years experience in crime scene, I have worked a lot of deaths, unfortunately, due to homicide and sometimes suicide. So on top of the training and the hands-on experience, I can attest that a .22 caliber firearm would leave a very small hole in regardless of what it is impacting. So that made sense to me in us not really being able to see large holes on the victim when we recovered him from the river that day. So that made sense to me. Plus it would make sense to me for maybe someone not hearing an assault that occurred with the victim.
Objection, Your Honor.
Just saying, unless she's a ballistics expert. I'll strike that last statement.
But if I can, I'll rephrase a question.
All right.
Counsel has asked a number of other law enforcement witnesses if there were any reports of shots fired on the night that Greg Rice was killed. Based on your experience with different handguns or firearms, would the caliber that was used have any effect on that?
Sustained.
Okay. In your experience, you said that you've processed a number of scenes, whether they're homicides or suicides, in your 20-plus year career. How many cases involving shootings have you responded to or participated in?
Hundreds.
For each one of those cases, has there always been a call from anyone regarding shots being fired?
No.
Nothing further. I'm gathering Mr. Preston Burton will be asking questions.
Cross-examination.
Thank you, Ms. Wilson. In crime scene, that's what you are typically involved in crime scene?
I was at this time, yes.
Okay. What involvement do y'all have with 911 calls and reports? You're not getting that, you're part of the investigation, are you?
Oh, what do you mean?
Well, you're not getting information about whether or not there was a call from a neighbor about hearing somebody shoot a gun 5 times. All right?
So usually when we are investigating a crime, we do what's called a roundtable. And so the crime scene investigator gets with the detective and the supervisors, and everybody discusses the case as to how the call came in, what happened before, what the detective has, what the crime scene investigator has found, so on and so forth.
Okay. And so let's answer me this. Where is the crime scene? Where is the crime scene?
I don't know, sir. I can't tell you what the crime scene is.
Objection, Your Honor.
What?
The address, quite frankly.
Where's the crime scene?
I can only tell you where the victim was found.
Okay. So you can't tell us, as we sit here today, in a murder trial, where the crime scene was.
Are you asking me the question again?
I am.
Okay. No, I cannot tell you exactly where the crime scene was. That is correct.
Can you tell me, did you investigate any other potential crime scenes in this case?
In regard to this victim,
That's correct?
so we did search his residence
That's right.
and
No,
his.
I'm sorry, I didn't catch all.
Oh no, I was just saying. You go ahead.
And that was on October 16th, right?
Yes, that is before he was found.
Okay. And that was 2 weeks, right? About 2 weeks after the date of death?
So October the 16th is when I first learned that he was reported as a missing person. And they asked us to come and search his house. When I say they, the detectives asked crime scene to come and assist.
Okay. And you did that, right?
We did.
Okay. And to do that, did you park your car in the parking lot anywhere around the apartment?
Yes.
Did you get out of your car?
Yes.
Did you walk to the apartment?
Yes.
Did you take the sidewalk?
Yes.
And when you did any of that, you seem pretty thorough. When you did any of that, did you find any shell casings?
No.
Did you see any blood stains?
No.
2 weeks later, did anybody approach you and say, ho, 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 we're glad you're here because we heard some gunfire on October 2nd?
I don't have that information. I don't know.
Nobody approached you then? No neighbors approached you?
No.
All of these items that have been identified in your round table, did it ever get to you? Those were all items that Chris Don Tell purchased?
Yes.
He went to Lowe's by himself and got the center block, right?
Yes.
He got the zip tie.
I don't remember everything that he purchased, but I do know that that was mentioned during our roundtable.
That's right, the round table, they told you he got the center block, he got the tarp, and he got the zip tie and a Pepsi. Is that right?
Like I said, I don't know exactly what he purchased, but I do remember there being video of him at the store purchasing several items.
Okay. And when you were investigating Myrtle Beach Funeral Home, did you lift any fingerprints that were relevant to this case?
I don't recall lifting any fingerprints.
No fingerprints. Okay. How about any relevant footprints?
No.
Did you lift any, did you do any analysis for Megan Jackson? You involved in that? Did you see any, did you try to lift any fingerprints for Megan Jackson?
No, I did not.
Did you do that at Greg Rice's apartment?
For fingerprints?
Yes, ma'am.
No, I did not.
Did you get any footprints of Megan Jackson at Greg Rice's apartment?
We didn't look for footprints. We did spray the apartment.
Oh, that's right. Did y'all get a sample, like a little sample for Greg Rice's DNA?
Like his hair brush and his toothbrush, yes.
And why would you collect that evidence?
Objection, Your Honor. Captain Wilson is actually not the investigator who collected those items.
But if you notice why it was collected, a whole lot of questions.
So like I was saying, he was reported missing at the beginning of October, and then October 16th, when we were doing the search of his residence, because he had been missing for that long, we wanted to have something with his DNA to have as a standard so that we could send a sled in the event he were found.
And that was in fact done, correct?
Yes.
And when you, at one of your roundtables, did you get to hear that blood was found on the shoe of Chris Dontel? Isn't that right?
Yes.
But not Megan Jackson?
Like not her shoes?
Not anything related to Megan Jackson? No article of clothing of hers had any of Greg Rice's blood on it. Is that correct?
As far as I know.
As far as you know. Well, we got it on the top of Chris Dontel's shoe and the bottom. Isn't that right?
I don't remember where it was on his shoe, but yes, there was blood on his shoe.
Your Honor, close the door, please. I don't have any further questions, Your Honor.
All right, correct.
Just very briefly, Your Honor. So if, just trying to do my math. Greg Rice is killed on, Greg Rice is killed on October 2nd. The body is recovered, his body is recovered November 7th, 8th, so a little more than a month passes, correct? Am I doing my math right? October
Yeah, I don't know the exact date that he was killed. I just know he was reported missing, I think, around October 4th or 5th, and then we were at his place on the 16th, and then his body was found on November 8th.
Would the passage of time from October 2nd to even October 16th, would that potentially make a crime scene more difficult to find?
Yes, it could very well. Plus, depending on the weapon that is used or how someone dies will depend on how much blood would be present to begin with.
If Gregory Rice was shot down the street from his apartment on the road leading out towards Clay Pond Road, would you expect to find shell casings or blood as you parked your patrol car in the parking lot, got out of your car, walked on the sidewalk, and conducted your search at his apartment if he was killed down the road?
No. And we would have no reason to go down the road searching for that unless the detectives were able to canvass the area and get video surveillance to say that, hey, we saw the victim walking this direction, and then we would go search that area.
If the location where Greg Rice was killed was not learned by investigators until more than 4 years after he was killed, would that affect your ability to collect any physical evidence from a crime scene?
Yes, if it's on the roadway or on the side of the road, just due from traffic going up and down the roadway, and then you have lawnmowers cutting the grass and so on and so forth.
Nothing further, Your Honor.
All right, you may sit down.
Your Honor, I would ask that Captain Wilson be released from her stand.
Any objection?
No, sir, Your Honor.
All right, you're free to go.
Thank you.
Jake, can call your next witness.
Your Honor, the state calls Drew Edwards.
your right hand and put your left hand on the Bible. You solemnly swear on affirm the evidence trying to give the court in this case is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Get you to state your name and then spell your last name for the court.
Yep. My name is Christopher Drew Edwards, Edwards.
Court's indulgence, I'm struggling. Your Honor, it's my understanding that there will be, and there will be more exhibits that I will offer through this witness, but States Exhibit 59, 60, and 61, along with Exhibit 149. I believe there's no objection to their admission.
Any objection?
Yes, sir, Your Honor.
States Exhibits 59, 60, 61, and 149 are admitted in evidence.
May I, Your Honor?
Yes.
Thank you. Detective Edwards,
Yes, ma'am.
where do you work?
I work for the Horry County Police Department.
How long have you worked there?
18 years, since October 2006.
What is your current assignment?
I'm currently assigned to the Narcotics and Special Operations Division as a gang investigator
How long have you been in that assignment?
since April of last year.
What was your assignment back in October of 2020?
I was assigned to the violent crime section of our investigations division.
So what types of crimes did you investigate?
We investigated anything from homicides, armed robberies to overdose deaths.
What types of things did you do during the course of those investigations?
Common things we would do, we find witnesses, interview them, canvass areas where the crime occurred to find any video or evidence that we could find.
And that's not a comprehensive list?
No.
When an investigation comes in, how is it assigned to a lead investigator?
So if it's a call out, like something happens in the middle of the night and they need an investigator right away, the on-call person would get it. If it's something that happens over the weekend and it's like a property crime, it would be assigned, the next business day.
And is it common for other investigators to assist the lead investigator with some of these tasks that you have to do?
Yeah. Some of these cases can get very complicated with a lot of work to do, so the work can be split amongst different investigators.
Directing your attention to this case, did you become involved in the investigation into the disappearance and murder of Gregory Rice?
I did.
Were you the lead investigator?
No, ma'am.
Do you know who was?
Detective Susie.
Did you, in fact, however, help Detective Susie with some of the assorted tasks?
I did.
So directing your attention first to November 8th of 2020, did you respond to a call about a body being found in the Little Petey River?
I did.
And Your Honor, may I put Exhibit 51 up again? It's been admitted and published. Were you familiar with that area prior to responding there?
I was.
Can you describe that area?
Yep. So Pitt's Landing is on Highway 378. It's as you're exiting Conway. It's like one of the last things in the county before you get into Marion County. It's a boat landing. It's a dirt lot surrounded by trees, and then you have the river.
Is that an accurate representation of that area?
Yes, ma'am.
What did you see when you got there?
When I first got there were patrol vehicles, and I believe some fire personnel were on scene.
Were there any civilians there as well?
Yes, ma'am.
And Captain Wilson testified about the kind of county boundary that runs through the river. Did that present any sort of unique jurisdictional issues?
Yes, ma'am. For us to investigate it, it would have to be within our jurisdiction.
So on the Horry County side?
Yes, ma'am.
Okay. When had Mr. Rice's remains been removed from the river when you got there?
No, ma'am.
Were you there when they were eventually removed?
I was.
Okay. What's going through your mind at this point?
So we were once I got there, I had to wait on Marion County crime scene, and the fire department was sending out their dive team, so it took a little bit of time for all those resources to get there. The prior month, Gregory Rice had been reported missing. I know through some of the investigation, we had obtained some cell phone records for people close to him. So while I was waiting on them, I looked at a program called Cellhawk to see if any records showed anybody out that way near the boat landing during that prior month. There was one record that showed Chris Dontel out there a day or two after Gregory Rice had been reported missing.
So did that lead you to believe anything in particular?
That it's not very often you find a body dumped in a river. So led me to believe it could possibly be Gregory Rice.
And I may have asked you this before, but did you remain on scene as the body was removed from the river?
I did.
Okay. Can you describe what you saw when the fire rescue boat got back with his reins?
So when the fire rescue brought the body back in, there was a tarp that was secured on each end with zip ties. There was a ratchet strap attached to it with one cinder block attached to the ratchet strap. The body was in a very advanced state of decomposition and could not identify him just by looking at him.
So I'm just trying to find another. Honestly, I don't feel like carrying the cinder block again, so I'm going to approach with the State's Exhibit 149, which I believe has been admitted without objection from. Does that look to be a photo of the cinder block that was recovered?
Yes, ma'am.
Your Honor, made that be published? Yes. Did you notice anything unusual about the cinder block?
It's not a cinder block you typically see. It's, I'm pretty sure everybody can picture a cinder block in their head. This one, if you turned it sideways, it had little tiny slots in it instead of a big open square. Kind of stood out.
It's showing, if I can republish State's Exhibit 54. All right.
Yes, ma'am.
And Captain Wilson identified the tarp and the zip ties. Were you there when, and you can see the ratchet strap in that photo, were you there when that was recovered?
Yes, ma'am.
And Your Honor, I don't believe there's any objection to the admission of State's Exhibit 126.
Any objection?
No, sir.
All right, State's Exhibit 126, admitted into evidence without objection.
Is that the ratchet strap?
Yes, ma'am.
Your Honor, I would ask that this be published to the jury.
All right.
Were there, when Mr. Rice's remains were removed from the tarp, did anything catch your attention as being significant to him?
Yes, ma'am. So we had a Facebook photo of Gregory. He's wearing a black ball cap with a Punisher logo on it. He's also wearing a Village Surf Shop t-shirt. And we've been told he liked to smoke Marlboro Reds. This person had a pack of those in his pocket. He was also wearing he was described always buy cheap shoes from Walmart. It's just what he liked to wear, and that's what this person was wearing.
Now, let me go back to the tarp. It's wrapped up in a nice biohazard kit. Were you able to look at the tarp from State's Exhibit 55, which has already been admitted and published?
Yep.
Was there anything in particular about the tarp that you were able to use as an investigative lead to find out where it had been purchased?
Yes, ma'am. The brand on it led us to look at Lowe's home improvement stores.
Were you looking just for the tarp, or were you looking for other items like the ratchet strap, the zip tie, the cinder block?
No, we were looking for somebody that might have purchased all those items together.
Were you able to find any evidence of a transaction where all of those items were purchased together?
We were.
And where had that purchase been made?
The Lowe's home improvement store on Seaboard Street.
Who did you speak to when you went to the Lowe's home improvement store?
Loss prevention employee named Robert McKnight.
And I'm approaching with, Your Honor, these have been admitted without objection. So that's State's 59. Oops, bless you.
Bless you.
60 and 61.
Yes, ma'am.
Are those items that you received from Mr. McKnight?
Yes, ma'am.
Your Honor, I would ask that 59, 60, and 61 be published to the jury.
All right.
Start. And what is depicted in State's Exhibit 59?
It's a tarp ratchet strap zip ties and cinder blocks.
So newer ones, right now the ones.
Yeah, these are just like stock images from Lowe's.
I'm sorry?
It's like a stock image from Lowe's.
And showing you State's Exhibit 60 for those. What is depicted in Exhibit 60?
That would be a transaction receipt for the items purchased on October 3rd, 2020.
And does that also have a timestamp on it?
Yep, so it says 14:54 hours, which would be 2:54 p.m.
And then if we could bring up Exhibit 61. What is depicted in Exhibit 61?
That would be Christopher Dontel with the items in his shopping cart.
Your Honor, I'm approaching with Exhibit 62 and 63. I believe there will not be an objection, but Detective Edwards, do you recognize State's Exhibits 62 and 63?
Yes, ma'am.
What do you recognize them to be?
Surveillance video, and I think it's what surveillance video.
Is one from the point of sale and one from the parking lot?
Yeah.
Are those both from the Lowe's improvement?
Yes, ma'am, on Seaport Street.
And how do you recognize them?
I signed them.
And did you review them as well?
Yes, ma'am.
So, did the stills depicted in Exhibit 61 appear to come from the point of sale surveillance video?
They do.
And you said that you reviewed the parking lot surveillance video.
Yes, ma'am.
What, if anything, did you see that would be relevant to this case in the parking lot surveillance video?
After Dontel purchased the items, he took them outside and placed them into his county-issued Ford Explorer.
Probably should have asked this before, but were you familiar with Christopher Dontel prior to this investigation?
I was.
How?
From working violent crimes, we deal with coroner's office, unfortunately, pretty frequently, and I'd worked cases with him before.
Were you familiar with the defendant?
I was.
And how?
She comes to pick the people up whenever they pass away.
Of course it will. Nothing further at this time. If you'd answer any questions from Mr. Preston in written.
Yes, ma'am.
Thank you for being here.
No.
Just got a question, really.
Yes, sir.
The cell hawk stuff, did you do that? How did you get cell hawk that?
I just logged into the website.
Okay, like, you weren't involved in any kind of extraction for phones?
No, Cellhawk would be like cellular CDR records. It wouldn't be like an actual download of a phone.
It's not download,
It's like call detail records.
Call detail
Somebody had,
Gotcha.
Yep.
Okay, thank you. Maybe out of just curiosity, but these cigarettes in his pocket, I mean, they've been in the water for 30 days. I mean,
well, it was a pack. I didn't like open the pack of cigarettes.
it was a sealed pack.
I don't remember if it was sealed or not.
And just want to confirm that receipt, we did have a Pepsi.
Pepsi Zero.
Pepsi Zero.
Yep.
Yep.
We wrap?
No, Your Honor.
All right, you guys got that?
May we approach on scheduling now?
Yes.
Oh, Your Honor, may Detective Edwards be released from his subpoena?
You got it. No objection, Your Honor. I was pretty good. Thanks.
Sorry, this is the end of this day. So we're going to go over to day 2. I think it gets interesting in day 2 from what I hear. Sorry, this is the end of this day. So we're going to go over to day 2. I think it gets interesting in day 2 from what I hear. Sorry, this is the end of this day. So we're going to go over to day 2. I think it gets interesting in day 2 from what I hear. Sorry, this is the end of this day. So we're going to go over to day 2. I think it gets interesting in day 2.
Please raise your right hand and place your left hand on the Bible. Do you solemnly swear or affirm the evidence about to give the court in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Get you to state your name and then spell your last name for the court.
Arthur, Reginald Hoteling Jr., Hotaling.
Good morning.
Good morning.
Are you currently working?
I'm not.
Are you starting a new job soon?
I am.
What are you going to be doing?
Working for the South Carolina Highway Patrol.
Okay. And did you previously work in law enforcement?
I did.
Where did you work?
Marion County Sheriff's Office.
How long did you work at the Marion County Sheriff's Office?
About 14 and a half years.
Did you have any law enforcement experience before you went to work at the Marion County Sheriff's Office?
I did. I worked almost 2 years, right at 2 years in Mullins Police Department.
I'm going to turn your attention back to around October 2020, October, November 2020. Do you remember what your assignment was with the Marion County Sheriff's Office back then?
At that time, I was the senior investigator.
What were some of your duties and responsibilities as a senior investigator?
Respond out to call-outs, investigate various crimes, from felonies, misdemeanors,
Everything?
everything.
Okay. So think back to November 8, 2020. Were you asked to respond to the scene of a body at Pitts Landing?
I was.
Where's Pitts Landing located?
It's right off of 378 in Marion County. It's at the end of 908, around, or go down almost to PD Highway from 378 from the Marion County side.
And what river is located there?
The big PD.
Are you sure?
Or the little PD, yeah,
Okay.
it meets down in the
It
bottom.
meets, but it's the
Yeah.
little PD there.
It's the little PD there.
And do you know that the Little Petey River is the geographical boundary of Horry and Marion County?
It is.
Okay. What did you see when you got there?
It was dark. Just the river landing.
Were there people there?
There was a few people, but not many.
Okay. What kind of people were they?
I think they were just camping or fishing.
Okay. Did you do anything once you got there?
I did. I think, if I remember correctly, I had I think the people that were there may have taken a picture or something of what they saw, but they weren't real sure. So then I called my supervisor, kind of let them know what was going on.
Did the fact that the Little Petey River is the geographical boundary of Horry and Marion County create any difficulties for you when you got there?
It did.
Okay, what were those?
To find out which side of the river this body was on, in a bend in the river, it just made the line to determine whose case it was going to be.
Okay. So who did you call out to come to the scene?
If I remember correctly, I had called my supervisor, Captain Barker, at the time, and she had told me that we could call Horry County and have Horry County come out to kind of assist with determining if it's our side or their side.
Okay. And did Horry County come out?
They did.
When you got there, did you see the object that the civilians had called police about?
I couldn't from there.
Okay. Do you recall receiving some evidence that was recovered from the body in this case?
I did.
I'm going to approach.
I'm trying to keep it one more.
Your Honor, may I approach?
Yes.
I'm going to approach with what's been marked as State's Exhibit 57. And is that what's commonly called a chain of custody form? Evidence record?
Yes.
Okay, and so what kind of items did you receive from the scene?
A lighter, a pack of cigarettes, a cinder block with a toe strap, a ball cap, sheets, a tarp, some zip ties. A tarp. Yeah, there was just that kind of stuff.
A number of items.
A number of
Were those items recovered with the body that day?
Yes,
Were you asked to sign this form showing that those items were given to you?
I was.
Do you see your signature on this form?
I do.
Is it right here?
It's actually okay.
Right there. Okay, sorry. Hard to read. Thank you. Once she received those items of evidence you just described, what did you do with them?
We actually took those items back to our department and put them in like a evidence locker room temporarily.
All right, I'm going to direct your attention now to November 2th, 2020. Did you attend the victim's autopsy?
I did. Yes.
At the conclusion of the autopsy, were you given certain items of evidence collected at the autopsy?
I believe I did.
Okay, I'm going to show you what's been marked as State's Exhibit 58. Madam President?
Yes, ma'am.
I'm going to show you what's been marked as State's Exhibit 58. Okay. And what items of evidence were you given at the conclusion of the autopsy?
The clothing, black belt, black sneakers, jeans, sweatshirt, socks, shirt, a bullet, blood spot, photos, bullet.
So how many bullets did you count?
2, 3, 4, 5.
And is that your signature on that form saying you received those items?
It is.
I'm going to show you what's been marked as State's Exhibit 139. And you can look at them if you need to open them, you will. Are those the bullets you collected from the autopsy that day?
It is.
139, yes. I think so. Okay, what did you do once you took those bullets into your custody?
If I remember correctly, I took them back to our evidence as custodian.
So you stored them in your property and evidence?
Yes.
Is that standard practice at the Marion County Sheriff's Department?
Yes.
Okay. At some point in the future, did you turn those back over to Horry County?
I did.
Oh, Your Honor, at this time, the state seeks to introduce Exhibit 139 evidence.
Any objection?
No objection, Your Honor.
State's Exhibit 139, admitted into evidence without objection.
No further questions, Mr. Chairman.
Cross-examination.
Please, Court, Your Honor.
Yes, sir.
Maybe I missed it in there. When did you give jurisdiction over to Horry County?
I'm not exactly sure on the date.
You don't remember giving it to Horry County, you didn't see jurisdiction, so you go to the scene, you take all the evidence, you transport all the evidence, you store all the evidence, you start the investigation, and then Horry County gets in? How does that happen?
Afterwards. So when we were there, I contacted our sheriff as well. Because over there, we would let SLED come in and do a crime scene. But he was in agreement to let Horry County take like pictures of the crime scene, kind of process that crime scene for us to help us out.
Look, I'm not trying to be mean, just
No,
want to
you're
ask some
fine.
questions to clarify everything. So SLED gave permission to Horry County to take pictures, is that what you said?
Our sheriff.
Your sheriff? That's the first person you called, correct? Your supervisor?
No, Judy Barker was my
Judy
supervisor.
Barker was your supervisor, okay.
And she
So
contacted
you knew to call your supervisor?
Yes.
Because bodies found in Marion County, we got a problem.
Yes.
Bodies found in Marion County, we got a problem.
Yes.
And then you inventory, take all, store it, do everything you're supposed to do, right?
Yes.
Don't you feel like it's your case?
Well, we did until
Yes, sir,
it was
you did.
determined.
You sure did, didn't you?
Yeah.
Because it's in Marion County.
The body was located in
Right,
Marion County.
okay, in Marion County. Yes, sir. Yes, sir. It wasn't located in Horry County.
No.
And you started, what I would say preliminary investigations, you got some evidence from the scene.
Correct.
You got the body transported to NUSC, correct?
Correct.
You were there at the autopsy, correct?
Correct.
You took the bullets back, correct?
Correct.
So you did a lot of this stuff to get going, right?
Correct.
And then Horry County just swept them because they knew it was theirs. What claim did Horry County have to take jurisdiction? They didn't, did they? No, they didn't. They didn't have jurisdiction at all.
No.
Thank you. No further questions.
Mr. O'Malley, does the Marion County Sheriff's Department have a crime scene division?
No.
So who does Marion County normally call when you have a crime scene to process?
SLED.
Okay. In this case, did Marion County ask Horry County to process the crime scene?
They did.
At some point, if you know, was the body found dumped in the river identified as the victim in this case, Gregory Rice?
It was.
And at that point, did it become clear that the crime was an Horry County case?
Yes, that's correct.
Objection, Your Honor. How could he know? He just said he had no idea about the case. He found the body in Marion. There's no way he could possibly postulate there. He knows that Gregory Rice belongs to Horry County. He's got no idea where Gregory Rice is from unless he's told that.
May I respond?
Yes.
Your Honor, I believe that defense counsel specifically elicited testimony from this defendant asking him which county had jurisdiction and where the crime occurred.
Overruled, not allowed. Go ahead. All right, you may sit down. State and call your next witness.
The state calls Adam Skellett.
Please raise your right hand and put your left hand on the Bible. Do you solemnly swear or affirm the evidence about to give in court in this case be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Get you to state your name and then spell your last name for the court.
Sure. Sergeant Adam Robert Skellett, Skellett.
Mayor, Your Honor.
Yes, ma'am.
Thank you. Where do you work?
Horry County Police Department.
And how long have you been there?
This May will make 14 years.
What is your current assignment?
The current assignment is sergeant at the West Precinct over the Patrol Division.
What areas of Horry County does the West Precinct cover?
501 to Aner, Galvin's Ferry, out to Marion County, stretching all the way to Greensea, Nichols, out to Longs, across the North Carolina border to 905.
Big area.
Big area.
Okay. What are some of your duties and responsibilities as a patrol sergeant?
Basic patrol operations, answer 911 calls, also supervise corporal and about 4 or 5 private first class officers that we have.
How long have you had that assignment?
Since March of 2024.
What was your assignment before that?
Prior to that, I was in the investigations unit from 2020 to 2024. I'm sorry.
No, go ahead.
Worked in the special victims unit and also in the homicide robbery unit.
So directing your attention to October and November of 2020, you would have been working as an investigator at that point?
Yes, ma'am.
Were you in special victims?
At that time, special victims unit, yes.
So what types of crimes do special victims investigate?
Anything ranging from missing persons, sexually related crimes. We would also assist in anything that homicide robbery may need also with some of their cases too.
Did you become involved in the investigation into the disappearance and then murder of Gregory Rice?
Yes.
How did you become involved?
In reference to this case, on October 19th, I was tasked with going to the River's Edge community where the defendant and Christopher Dontel, co-defendant, they both reside at. The River's Edge community is located on Highway 90. At that time, we were looking for a surveillance video.
Did you in fact find that the community had surveillance video at the entrances?
Yes, there was 2 gates, and there's actually gate cameras right along the community and Highway 90. We found a phone number from the Waccamaw Property Management. I was able to actually contact them and left a voicemail in hopes to retrieve some video.
Were you eventually given video from the River's Edge community cameras?
Yes, a Brian Stewart, an employee with them, contacted me, and then the next day I actually met up with them and received, I believe it was 2 hard drives in reference to video surveillance.
And I'm approaching with what's already been admitted, States Exhibit 118 and 119, Your Honor. Are those the drives that you received from Mr. Stewart?
I believe so, yes.
Okay. Did you review those videos?
Yes, ma'am.
And were you focusing on October 2nd of 2020?
At the time, yes, yes.
Did you in fact find any relevant, I guess I'll call them captures from those cameras?
Yeah, both of the co-defendants' vehicles that we knew that they were operating.
And I've shown these to defense. I'm approaching with States Exhibits 136 and 138. Are those stills from those videos?
Yes, ma'am. And those are my initials on them as well.
Okay. Your Honor, I would ask that States Exhibit 136 and 138 be admitted and published.
Any objection?
No objection, Your Honor.
All right, States Exhibits 136 and 138 admitted into evidence without objection.
And I'm going to first go with 136 and then I'll show the jury. Can you tell me, is there a date and time stamp on this photo?
Yes, October 2nd, 2020. It shows the time of 6:16 p.m.
And what car do you recognize in that photo?
The defendant, Megan Jackson, and that's her vehicle.
Is she entering or leaving River's Edge?
I believe that's her entering. No, I'm sorry, that's exiting. Sorry, the porch is on that side of the driveway. I'm sorry, that's exiting.
Okay. So this is October 2nd at 6:16, leaving River's Edge. And then State's Exhibit 138, does that also have a date and time stamp on it?
Yep, same date, October 2nd of 2020, and that shows 18:20 military time, so that'd be 6:20 p.m.
So just
Apologize.
about 4 minutes later?
Yes.
Okay, and whose car do you recognize in that?
That's Christopher Dontel's gray color Ford Explorer.
Is he also leaving the community?
Yes, ma'am.
How is it that you recognized Mr. Dontel's and the defendant's cars?
Okay, in reference to Mr. Dontel's vehicle, I believe that's actually the county-issued Ford Explorer that they issued out to the coroners. I've been on multiple calls for service while on patrol in reference to him showing up as a county coroner. Same with Megan Jackson, too, the van that she'd be using also.
So you were familiar with that?
Yes.
Court's in order.
Equation at all in the least.
Fair enough. Judge, do you think, now, I'm more sort of a criminal defense attorney, so, when we start talking about 3 times, 4 times, 5 times retrying someone, I wonder if you feel like maybe there should be some limit as to how many times someone could be retried.
I think so personally, but there is a way to accomplish that limit. The judge, we looked this up together, and the law in the state has the ability to dismiss either with or without prejudice, meaning it can be brought again or not, new charges. So the reality is the judge has a say in it, and she may step in and say, no, thank you, we're not doing it again. Bob Bianchi, I don't know if you had a chance to watch closing arguments. Of course, the defense went first, followed by the Commonwealth. And if you want to watch great attorneys, to me, you watch this trial because they're very good attorneys. They know what they're doing. And I felt like the Commonwealth really stuck to the data, the science. They really said, listen, the defense experts didn't have any science. And the defense leaned into Proctor and the investigation and some of the emotional pieces of it I thought that they brought out. How much does this affect a jury if it does the closing arguments?
I think closing arguments affect the jury tremendously. I believe opening statements are more persuasive in my mind, however, than closings. But closings, look, when you try a case, at least when I train people on how to try a case, whether you're a defense lawyer or prosecutor, I say you need to go to what you want to say in summation. Because, as you know, you can only comment on the evidence that was adduced during the course of the trial and reasonable inferences drawn from that evidence. Once I know, like I'm preparing a homicide case right now. Now, I know what I want to be able to say to that jury. I map that out first, and then I back my way into the witnesses and the evidence that I'm going to need to make sure that, one, I have it, 2, that it's admissible. You got to make sure that the light of the evidence will go into the jury so that the jury can listen to it. And then 3rd, so I'd be able to go in my summation and say the things I want to say because I've already built my case from the summation first. So look, I mean, emotions are important. The defense only has to play to one juror. Of course, they want an outright acquittal, but they want to be able to get to that one person. So they're going to be more in that emotional space. It sounds like I didn't see the openings here, where the prosecutors always want to be more methodical. The prosecutors don't want to work so much on emotion. They want to work on hardcore, solid evidence that's going to convince that jury beyond a reasonable doubt in a dispassionate way. Last point. Once a jury feels that the prosecutor is overly invested emotionally in the case, then there could be something where the jurors say, I don't know whether I trust this prosecutor. That's why prosecutor summations and defense are always so different.
Yeah, I think it's fair to say that the prosecution in this case took that methodical approach, the more scientific approach this time. All right, Bob, stand by. Folks, we're standing by to figure out what exactly is going on in the courtroom. We showed you about 10 minutes ago, Karen Reed returned to the courthouse. So what we'll do here, we'll take a break. And coming up, Court TV's Matt Johnson will join us live from outside that courthouse with all the latest. So keep it here on Court TV.
I guess we wait, y'all. I'm just cleaning off my dresser, so we shall wait. I highly doubt it's a verdict too. They ain't been in there but what 2 hours, but it could be a question because I could have sworn Bev told them that they are staying into 5:30 to deliberate. So they still got 30 minutes. Well, they have been sent home for the day. Yep, I just saw the tweet that says the jurors asked to go home. They deliberated about an hour and a half and will return on Monday. So I figured they was either gonna go home or they had a question. So I do think that on Monday we will get a verdict though. We will get a verdict. All right, so I'll actually go ahead and end us for the day as well. I got some stuff that I want to do, make my weekend more cozy in here. So I shall see you all on Monday. I'm actually gonna keep watching this Megan case because it's super interesting to me. So I hope y'all all have a good day. Hopefully, I'll catch y'all in some comments somewhere. So I shall see y'all later.